as we were doing in earlier in VC.
Memory lane is bad. Bad memory.
Yes.
Page 2.
So
Recording in progress.
any memos for this week
One memo is there
for listing?
for listing old matter. It can be disposed of with the consent of the both parties.
When do you want, sir?
The transfer of file the transfer of the CP from Jagatsinghpur to Qatar. So I have no objection.
So both the learned counsel have signed the memo. ଆପଣ ଉଭୟ ସାଇନ୍ କରିଛନ୍ତି? ଜଏଣ୍ଟ ମେମୋ ଦଉଛନ୍ତି ନା ନାଇଁ?
Single memo if matter will be listed, it will be. I am for the opposite party. I have no objection if it will be transferred.
ତାହେଲେ ଏଟା କେବେ ଆଣିପାରିବେ? ନମ୍ବରଟା କହନ୍ତୁ। ଆପଣ ଲେଖିବା କାଗଜ କାଇଁ ଆପଣଙ୍କ?
303
ରିସିଭ୍ କରିବ।
ବର୍ଷା ଅଛନ୍ତି? ସେଠି ଜଣେ ବର୍ଷା ମ୍ୟାଡାମ ଅଛନ୍ତି, ସିଏ ରିସିଭ୍ କରିବେ। ଆପଣଙ୍କ ଇନଷ୍ଟ୍ରକ୍ସନ କଣ କୁହନ୍ତୁ? ମୋର ଫର ଅର୍ଡର୍ସ। କାଲି ଅର୍ଡର ସେ ଆଣନ୍ତୁ। Yes.
Item 42.
Page wise, sir. Page wise. We'll go page wise. Same thing.
Item 5 to 12.
Item 42.
5 to 12, sir. 5 ରୁ 12.
Nine.
Page 3, 13 to 18.
ତାଙ୍କ ଭଏସ ଆସୁଛି? ସେ ଯୋଉ କହୁଛନ୍ତି କୋର୍ଟ ମାଷ୍ଟର ତାଙ୍କ ଭଏସଟା ଆସୁଛି 13 to 18?
ଆଜ୍ଞା।
ଆଚ୍ଛା।
Page 4, 19 to 26.
38 my lord. No, page asini.
26 19 ରୁ 26 ତାପରେ 27 ରୁ 30
item 27.
yes sir.
I have already consulted with Mr. Jena
Yes.
for filing of objection in this condonation of delay petition.
Yes.
Take it after vacation. Reopening day, I will file my objection to the condonation of delay.
27 ଟାକୁ ଡେଟ୍ କରିଦିଅନ୍ତୁ। ଆଇଟମ 27 ଟା ଡେଟ୍ କରନ୍ତୁ। ଆପଣ ଆଣିଛନ୍ତି ଆପଣଙ୍କ ଚିଠା? ଅଛି ଚିଠା କେତେଟା ଫୋଟିଂ ହେଇଛି? ଚିଠାଟା ଆସିଛି? ଯଦି ମଗେଇ ପାରିବେ ଦେଖନ୍ତୁ ଚିଠା। Week commencing 29 Mr. Sarkar.
My lord.
Yes.
Problem.
28 to 30.
Page 6, 31 to 38.
My lord, item 35.
Yes, please.
Matter is under process of amnesty, my lord.
Okay.
My lord may call this matter after vacation.
Okay.
We counseling 20 sir.
Item 38, my lord.
Yes, 38.
38 ରେ ସାର୍ ଆମେ ହେଲୁ ଅପୋଜିଟ୍ ପାର୍ଟି।
Yes, sir.
କିନ୍ତୁ ବୋଧେ ଏଟା ହିୟରିଂ ମ୍ୟାଟର ଶୁଣି ହବନି ଭିସି ରେ।
No, I mean there will be some limitation. You are right. And as such, when I have to hear fresh admission and orders for hearing also, at times as you mark prolonged hearing, so it will take a date. But inform Mr. Subhasis Patnaik.
ଆମେ ସାର୍ ଅପୋଜିଟ୍ ପାର୍ଟି।
I understand, sir. That is how I am requesting you to inform Mr. Naik to inform the learned counsel for the petitioner.
ସାର୍ my lord.
We counseling 20 sir.
ଆଜ୍ଞା।
Yes.
Page 7, 39 to 43.
My lord, item 42.
42, yes.
42, this matter, my lord, after hearing, specifically directed it to taken up as orders because it is not reaching at it's a maintenance matter. Since last 3 years, I am suffering without getting any maintenance and suppressing many things. He has made it family court 5,000, which is nothing at staying at Bhadra. Okay. So I have a proof of income. I have filed all the income tax document, IT returns. 3 years I have done.
So after vacation for orders.
My lord.
Orders ପାଇଁ କରନ୍ତୁ after vacation.
We commencing
Madam,
29/6.
41 also may be same. 41.
41 ଟା orders କାଇଁ ଆଣୁଛନ୍ତି ଆଜ୍ଞା?
My orders because that is a bank matter.
Orders ଆଣି ହବନି sir. Sir ଶୁଣନ୍ତୁ already we are burdened with fresh and orders matter which we have to hear.
My lord, oblige.
41 ଟା କେବେ କୁ ରଖିବେ for admission?
We commencing 27/7.
27/7 Mr. କର 41
Right.
41 27/7 42 ଟା 29/6 orders.
Oblige.
Page 8, 44 to 50.
My lord, item 50.
Why Mr. Senior Mr. Sodangi is not showing? He should sit down. We are unable to see his beautiful face. Sir, namaskar.
other side 44 ଟା ଯାଇଥିଲା mediation କୁ successful ହେଇଛି ଏଟା order ସେ ଯଦି କାଲି କି ଶୁକ୍ରବାର ରହିପାରନ୍ତା
44 ଟା to be mentioned. କୋଉ ଦିନ ଆଣିବେ?
other side କାଲି କଥା ହେଇଥିଲି
ଆପଣ ସୁବିଧା ମତେ ଡେଟ୍ କହିପାରିବେ ତ? ଆଜି ହେଉଛି କି ବାର?
ଆଜି ମଙ୍ଗଳବାର
ଆଉ ଗୁରୁବାର ସାର୍ ଆସିବ?
ଗୁରୁବାର ସେଇ ଭିସି ହେଇଯିବ
ଆଚ୍ଛା ସେ ଚାହୁଁଛନ୍ତି
Friday
ଇଏ କରିବା ପାଇଁ ଫ୍ରାଇଡେ କଲେ so that's a Friday Friday with report.
ରିପୋର୍ଟ ଟା ବୋଧେ ଅଛି
ଆପଣ ଏପଟକୁ ବସ ଏଇଟା ୟୁଜ କରନ୍ତୁ ସେଟା ଚେୟାର ପକେଇ ପାରିବେ ଗୋଟେ ଚେୟାର ପଡିବ ସେଠି ଦିଟା ଚେୟାର ପଡିବ ଟେବୁଲଟା ତ
ରିପୋର୍ଟ ଟା ବୋଧେ ଅଛି
କହନ୍ତୁ ଆମର to be mentioned Friday.
Friday এটা interim order ଟା ତାଙ୍କର ଥିଲା ଆମେ opposite party may be continued
Interim order ନା ଏଇଟା ବସି interim order touch ହଉନି so ରହିଲା
ଆଜ୍ଞା
interim order is not being touched.
My lord, item 50.
oblige your lord
Yes please.
My lord, item 50.
Just give me a second. ସେ ଆମର ଏଠି ସବୁ technically
Nesty, my lord.
ସେ ଆରଟା କେବେ କୁ ରଖୁଥିଲେ
27.
27 ହବ ତ? Can you hear me?
My lord.
27 ଠିକ ଅଛି ତ?
My lord.
Yes, please work out the amnesty.
My lord.
Yes, 27.
Page 9, 51 to 54.
Okay, follow the list.
Item 1.
My lord, on behalf of Bharat Kumar Jalli, kindly taken up after vacation.
Mr. Sahoo, Mr. Nanda, anyone present for
I may be pardoned to make a mention.
Yes, please.
I'm not,
Yes, Mr.
Not able
Yes,
to
yes.
connect. But item 40, madam.
40, yes.
It's a matter is being
Mr.
influenced.
Das, Mr. M.K. Das.
My lord.
Yes.
Now the petitioner.
40 you are saying.
My lord, item 40.
Yes.
Now the petitioners, this matter became infructuous. In the meantime, wife's maintenance proceeding has been dismissed.
Fair enough. It will be taken up. So
this way.
So unlikely to reach. Because once we start hearing, no, but you have to mention. Both of you can mention. I cannot preempt the other side and take up the matter.
I shall intimate to my learned senior Mr. Bhuyan.
No, apart from intimating, if you want hearing, both of you want hearing, no difficulty. So both of you mentioned it can be taken up today, even if you are. I mean, if he is available and you are available. We are saying that. So
before raising even, the Lordship can dispose of this matter.
So both of you please mention. Remain present. Yes. Yes.
Item 40, my lord. I'm Mr. 40 my lord ଅଛି. I'm associate of Mr. Bhuyan.
ତାଙ୍କୁ ଆଣନ୍ତୁ 40 ଟା ଆଚ୍ଛା ହଁ ସେ ଆସିଲେ ମିଷ୍ଟର ମହାପାତ୍ର ମିଷ୍ଟର ଦାସ ମିଷ୍ଟର ମହାପାତ୍ର ଇସ୍ 40 ସେ ଆସିଗଲେ
my friend must be fair enough to say And now the maintenance proceeding is already disposed of, my lord, out of which this matter has been arised.
Sir.
Mr. Mahapatra, can you please obtain instruction?
Yes, my lord. My lord, I will.
You have heard Mr. Das, he is saying that the main application out of which this petition arises has been disposed of.
My lord, I will take instruction, my lord. Roshi may pass over this matter.
Okay.
Before night. Any time before night.
So you have the contact of Mr. Mahapatra, Mr. Das number.
I will call his associate, Mr. Sohan.
Yes. So be in touch. So whenever you both of you can mention it. That Mr. Das is mentioning.
Oh, bless.
Yes.
My lord, I may be excused, my lord. Item 11. I pray, my lord, take up this matter after vacation because the other matter could not be listed. So I pray, my lord, take up this matter after vacation, my lord. Item 11.
Just 1 second. Just give me a second.
My lord.
Just give me a second. Move file ta dekhibi.
My lord.
Mr. Niranjan Singh, my item 11 likhantu. Mr. Niranjan Singh for the petitioner. Opposite party blank. The matter being listed for fresh admission is mentioned at the beginning of the day's proceeding. In the virtual court by the learned counsel for the petitioner seeking adjournment. The matter was had at matter was had earlier at length. On 12/1/2026. Thereafter, the effort of the learned counsel for the petitioner has been to adjourn the matter on 31/1/2026, 4/2/2026, 25/3/2026, and 1/5/2026. Stop. To grant further opportunity to the petition, so far, the matter shall be listed in the for fresh admission in the week commencing 20/7/2026.
Obliged.
Yes.
Item 1.
Item 1, my lord, Hon'Ble Bharat Kumar Dwali, kindly taken up after vacation.
Mr. G.N. Sahoo, Mr. A.K. Nanda.
No one is.
Search Kornanti, find a participant, G.N. Sahoo, G.N. Sahoo. Nahandi. पूरा टाइप करो A.K. टाइप करो नहीं ठीक है the matter is taken up for the hybrid mode the matter is taken up in VC थोड़ा किसी लिखिया पड़ेगा Mr. Polai, you are Mr. S.K. Polai.
S.R. Polai.
Mr. S.R. Polai on behalf of the appellant. On behalf of the learned counsel for the appellant, 6 for adjournment. Item 1, Mr. Mahanti or Mr. Lenka, who is appearing additional standing counsel? Mr. Prem Kumar Mahanti, kindly unmute.
Mr. Mahanti.
Okay. Mr. P.K. Mahanti, additional standing counsel for respondents 1 and 2. Mr. A.K. Nanda.
My lord, I am there, my lord.
Mr. G.N. Sahoo for the R4.
My lord, I am there, my lord.
Yes.
I am there.
So he is seeking adjournment, Mr. Nanda.
Yeah, lord. What I will say, my lord. The notice earlier also passed over last year.
Yeah.
That is on date, my lord, 23rd of March 2026.
Scroll kahin hogi? Job kahin kochi?
Lordship said last chance.
Sitter no. More welcome. On a 16 लिखले 6 पर adjournment. The Lord Counsel for the R4 refers to the order dated 16/3/2026 and submits that. Already this court has observed that sufficient opportunity has been given to the appellant to prosecute the matter. Stop. The Lord Proxy Counsel for the appellant is also apprised of the fact that the matter is kept pending since 2015 and the efforts to adjournment would defeat the purpose of justice. Stop. However, to grant another opportunity, the matter shall be listed under the same heading in the week commencing 29/6/2026. Yes, next.
Item 2.
These two appeals, I'm the appellant.
Yes,
I'm the
yes.
appellant. But I have actually, to be very honest, I've gone through the orders.
Yes.
Nothing much is there. And without taking my concession, I've read them. I'll just give your lordship a brief background. Your lordship may see the written note. There is a genealogy. Lordship got it?
Mr. Bose is there for the other side.
Yes, my lord, I'm here.
So you will complete the hearing in the VC or you want?
My lord, it should be done. If your lordship may allow us in physical, it will be better, my lord.
Everything is concluded, my lord. Nothing is there. And my lord, friend Mr. Bose, my lord, interest is also protected. We don't have any grievance so far as Mr. Bose client is concerned.
No, it
So
must.
his interest is protected. A piece of land that he claims to have been purchased by his family members, that is not the matter of dispute. Rather, the petitioners, my lord, they had illegally, my lord, mutated the land, including his portion of share, his portion of the property also. So the learned court below has
You have heard our learned senior Mr. Mahanti that I think he has already gone through the brief and he states that there is nothing much. So we'll confirm, Mr. Mahanti, confirm the order appealingist. Mr. Akim Mahanti.
I have no objection anywhere, here or in court. I have no objection.
No. So today it will be concluded, Mr. Bose.
I'll just take for 10 minutes.
Yes,
Just.
both of my seniors are ready to do, I can assist, my lord. My is only limited that my property is not under the present dispute.
Yes,
but
that's what I
question
want
is,
to say.
I'll just take 10 minutes.
Tomorrow, so then tomorrow it will do it. So it will be easier if I don't pass any order, so that it has to be returned again. Order has to be typed. Simply, it will be posted in the computer for tomorrow. Tomorrow, I think we are going for physical. Tomorrow at the same position. Okay. So please be available tomorrow.
tomorrow can it be at 3 p.m., my lord?
Oh, no.
3 PM ତମେ ଖାଇବାକୁ ଯିବନି?
ଆଜ୍ଞା ତାପରେ
ଆପଣ ସିନା ମାନେ all of us will be available, but many of us may not be.
ଖାଇସାରିକିରି
may not like to be present in court.
All right, as your lordship pleases.
Tomorrow we fix a time at say
No, no,
like
ମୁଁ ଭାବୁଛି ସାର୍
at the convenience of the court and convenience of my seniors. I have nothing to say.
ठीक है tomorrow after
10:30 your lordship may take it up.
Tomorrow after mentioning it will be taken.
Yes, ma'am.
Yes. That would or you can agree for 12:30 like that.
No, as per the convenience of the court and my seniors, I have nothing to say.
No, since the senior has already said at 10:30, so after the mentioning, we'll take it.
Yes. That will be better. That will be better.
It will be there in the same list, in the same position, because I have simply adjourned posted in the computer. Okay.
Grateful, ma'am. Great.
Yes, please.
Item 3.
Three ki Nandi. Anyone present? Now Mr. Vijay Kumar Behra,
So Vijay Kumar Behra,
Ike Das,
Ikeda,
Mr. Mahanti, you are there in Prem Kumar Mahanti? Yes. Appellant, none. None appears for the appellants when the matter is called and taken up in VC. Virtual court. आपको ऊपर तो hybrid lecture किया होगा. The learned additional standing counsel is present for the respondent. None had appeared when the matter was taken up on. It is a holy king. Single. What is proof? Keypad use kariyo record. Scroll करो. None had appeared when the matter was taken up on 10-5-25 to the coordinate bench. On 18-26. Learned proxy counsel was present on behalf of the learned counsel for the appellate, and order was passed to implead the project proponent. As a respondent. Project proponent oblique requisitioning authority. Thereafter on 10-4-2026, none appeared for the appellate. On 10, by the said order dated 10-4-2026, the registry was directed to serve copy of the order as well as the next date of listing to the learned counsel for the appellate. Despite the efforts of the registry, appellate stop kar dele to. The office note put up by the registry indicates that the learned counsel has been informed over telephone regarding the next date of listing. Yes, Mr. Behra, kindly unmute. Unmute ହେଇଗଲେ ଯେ ସେ ଭୟ ଆପଣଙ୍କ ମିଷ୍ଟର ବେରା ଆପଣଙ୍କ ଅଡିଓଟା ଆସୁନି So Behra,
my lord,
yes, अब मोबाइल फोन रे करछथि ना कोन मोबाइल फोन
आगे my lord
एटा कोन करबा डिसमिस होबो
नहीं डिसमिस योर लॉर्डशिप में मु आ कनेक्ट हे पारनी मु थिली अपन मोबाइल ले कनेक्ट हे पारला नहीं
अच्छा कनेक्शन होबो ठीक अछि ना मिस्टर बेहरा इसका और लिख कौन नाउ
I am ready to argue my lord.
Okay, since it has to be heard, I mean, can it be disposed of in mediation? Any suggestion?
That once this matter has referred to the mediation, but failed. This matter cannot be settled in a mediation, your lordship.
Okay.
This matter can be disposed by my lord.
Okay.
I can't. Indicates that telephone. Has been informed telephone. The efforts of the registry has yielded results. The learned counsel, Mr. Behra, for the appellant is present in VC.
My lord.
Stop. Comma, he submits that earlier the matter was referred to mediation. However, it could not work out.
Yes.
And he submits the matter be heard as a regular matter. Accordingly, accordingly it is directed. The matter shall be listed for hearing.
Sure, hearing after vacation hours.
For hearing in the week commencing 27-24.
Highly obliged, my lord. Highly obliged.
Yes. Appearance will actually. Mr. B.K. Behra, one for the appellate.
Obliged, your lords.
Yes.
Item 4.
Item 4, I am for the respondent, my lords, in this matter.
Yes.
I have filed an application under section 340 of CRPC.
Say, just 1 second. Mr. Singh, please unmute your, please unmute. Yes, Mr. Singh, unmute korantu ago system, yes. Ebe hala. Kontu ebe? Mr. R.N. Singh. ଆପଣ unmute କରିବେ କୁହନ୍ତୁ ଏବେ କୁହନ୍ତୁ
I am appearing for the petitioner, my lord.
Yes.
Petitioner is not willing to go to the mediation center, my lord. So this case may be disposed of in the regular court.
Mr. Mahima Prakash Sahoo, I think you are present.
My lord.
So you have heard Mr. Singh for the petitioner. Petitioner doesn't want to go for mediation.
That's all right.
So it has to be heard.
Yes, my lord.
Writ petition item 4 likhiwe. Mr. R.N. Singh for the petitioner. Dr. Mahima Prakash Sahoo for the opposite party. The matter is taken up in VC. Yes, please.
May I pray to take up this matter after vacation, my lord? It has
to be because it can't be the matter is listed at the top of the list. If you agree for mediation, it can work out. But as it seems, since the petitioner is not willing, it has to be heard, so it has to go for hearing.
Yes.
Yes, Mr. Boysack, speak to the microphone.
In the meantime, IA has been filed invoking section 340 of CRPC, and copy has been served through WhatsApp. They are not presently available. I have sent.
I have not received the copy, ma'am.
Whatever you serve him, so maybe he's in BC, so you serve him, no difficult.
We'll serve it in the meantime. May I just say this? We have filed an application under section 340 of CRPC for offences committed under section 195 of CRPC. If my learned friend has any intention of filing a reply, he may file a reply before the next day.
Yes, you serve it. No difficult.
Yes, we'll do that.
My lord, copy has been served through WhatsApp today.
Serve it physically also.
Physically, we'll serve it. We'll serve it physically.
Likely that you see the counsel for the petitioner submits that the petitioner is not willing for mediation. The petitioner is the wife and opposite party is the husband.
That's right.
The petitioner is the wife in the marriage and the opposite party is the husband. Accordingly, the matter shall be listed for admission in the week commencing.
May I request my lord on 2nd of July if it is possible?
The week commencing 3rd July.
No, the week
केबे कहले आपण
27 जुलाई
No, 27 because up to that week actually the matters have reached already 100 about 100 120 so
all right. I am obliged.
Yes, please. Yes, next please.
Item 5.
This is the second content.
My lord, in this case,
This is the second content. The order was passed on 4/21/2022.
Yes.
Page 8. When they have not complied, I filed a contempt and the first contempt.
This is a which department?
School and Mass Education Department.
So you bring on record the present incumbent, that will help you.
my lord, already by the order dated 12/5/2026, the Commissioner cum Secretary has passed order complying the order of this Honorable Court, my lord.
So can you file the SOCOs enclosing that and serve copy on Mr. Misra?
My lord, I will serve, my lord.
Are you filing the SOCOs today?
Compliance affidavit, my lord. Already,
Compliance affidavit you are filing today?
Yes, no, not today. Time may be given, my lord.
Okay. Mr. Jitendra Kumar Misra for the petitioner. Mr. Prem Kumar Mohanty for additional standing counsel for the opposite party. The learned counsel for the petitioner submits that the order dated the learned counsel for the petitioner refers to the earlier order dated 18/3/2026. And submits that state is was to obtain instruction regarding compliance. Stop. In response, it is submitted by the learned additional standing counsel that in the meanwhile, the order has been complied with. He shall file the affidavit, compliance affidavit, given some time. How much time, Mr.
In the meantime, 4 years, 4 months has already passed.
Let it come after vacation. Let it come on
File
Friday.
file the compliance affidavit and by serving compliance affidavit, and the matter may be listed after vacation. Stop. Para. Accordingly, it is directed the compliance affidavit to be filed, enclosing copy of the order passed by the compliance affidavit be filed kar diyantu. Upon serving copy thereof on the learned counsel for the petitioner, the matter shall be listed for orders in the week commencing 29/6/2026. Yes, please.
Item 6.
My lord, in RPFM number 68/25,
yes.
In the previous date, one order has been passed by this honorable court, which has been forwarded to the trial court, but no action was passed in that order, my lord.
1/5?
My lord. No, 65. RPFM 65, 68.
68. Yes, 68.
25. On 1/5/26, one order has been passed by this honorable court, which has been forwarded to the trial court. But the trial court has not passed any.
What trial court has not passed it? Trial court is not a human being. So, ଆପଣଙ୍କର କେବେ posting ହେଇଥିଲା, କେବେ listing ହେଇଥିଲା, କ'ଣ order ହେଇଥିଲା, so all those things are material. ଆପଣ ତ ଏଟା ତ ଗୋଟେ automated system ନୁହଁ ଯେ ଗୋଟେ ପଠେଇ ଦେଲେ that will trigger something.
My lord.
May I please receive?
Yes.
I am appearing on sub item, my lord. In this case, my lord.
First item रे appear କରି ନାହାନ୍ତି ଆପଣ?
No, I will take instruction to appear on that case, my lord.
Achha.
So
Mr. Ravindranath Parikh, the matter is taken up in hybrid board lecture. The matter is taken up in VC. Fast photo sentence in virtual court. In virtual. The learned counsel for the petitioner is present at the virtual court, High Court of Orissa at Noagar, and addresses arguments. He refers to the order dated 1/5/2026 and submits that copy of the state order has been forwarded to the court at Noagar, executive court at Noagar. Mr. A.K. Behra, learned counsel, submits that he is appearing in a connected tagged matter RPFM 173 of 2025 he shall obtain instruction from the opposite party in this matter also. Stop. But Mr. Behra, this matter is nothing. He says that execution is pending. Actually, no prayer, there's no specific prayer. The execution be disposed of. But anyway, you appear. If you want, you can appear.
Yes, yes.
Yes. So
I'll take instruction and appear on RPFM 68 of 2025. This week I will pay.
It is submitted by Mr. Behra that he shall file Wakalatnama is duly executed by the opposite party within 7 working days. Stop. Upon filing of the Wakalatnama on behalf of the opposite party, the same shall be taken on record, scanned copy be updated. Second matter they kon kariba? Once 173.
Along with after vacation, madam.
Madam, say case से 545 दिन लेट ହେଇଛି ବୋଲି ସେ ଗୋଟେ ଆଇର ଡିଲେ କଣ୍ଟିନ୍ୟୁଏସନ ପିଟିସନ ଫାଇଲ କରିଛନ୍ତି
ଏଟା ଡିଲେ
କଣ୍ଟିନ୍ୟୁଏସନ ଫାଇଲ କରିଛନ୍ତି ତାର ଜବାବ ମଧ୍ୟ
ଡିଲେ କଣ୍ଡନ ମାଇଲ
এই কেসটা অলরেডি and disposed of by this honorable court by coordinator bench my lord the copy has already been filed by me to this in this honorable court
Mr. Barik list ତ ଦେଖେଇବ ନା ଆପଣ ଯଦି କହୁଛନ୍ତି 173 has been disposed of
173 ପାଇଁ ମୁଁ କହୁଛି ସେ ଯୋଉ ଫାଇଲ କରିଛନ୍ତି ସେଟା ମୁଁ ଦେଇଛି ବୋଲି
disposed of 173 disposed of ନା କୋଉଟା disposed of କହିଲେ ଆପଣ କହିଲେ ନା this case has been already disposed of by the coordinate bench
ମ୍ୟାଟରଟା ସେ ଯୋଉ ମ୍ୟାଟରରେ ଦେଇଛନ୍ତି ସେଇ ମ୍ୟାଟରଟା ଅଲରେଡି ଡିସ୍ପୋଜ୍ଡ ଅଫ ପୁଣି
ସେ ମ୍ୟାଟର କହିଲେ ଆଜ୍ଞା ନମ୍ବର ନ କହିଲେ ସେ ମ୍ୟାଟର ସେ କୋର୍ଟ କହିଲେ କିଛି ବୁଝି ହବନି ଆପଣ କୋଉ ମ୍ୟାଟର କୋଉ କୋର୍ଟ କହିବାକୁ ପଡିବ
ମାଇ ଲର୍ଡ
173 ଟା ଡିସ୍ପୋଜ ହେଇଛି ନା ପେଣ୍ଡିଂ ଅଛି
ନା ପେଣ୍ଡିଂ ଅଛି ନା
173 ଇଜ ପେଣ୍ଡିଂ
ତାହେଲେ କାଇଁ ସେଟା ଗପସେଟରେ ଆପଣ ବର୍ତ୍ତମାନ ସେଠୁ ଆପଣ ନୟାଗଡ଼ରେ ରହିଲେ ମୁଁ ଏଠି ରହିଲି ମିଷ୍ଟର ବେହେରା ରହିଲେ ହାଇକୋର୍ଟରେ ସେ ଭୁଲଭାଲ ହବ
ଆଜ୍ଞା
ଆପଣ ଏଟା ଅର୍ଡର୍ସ ପାଇଁ ଆସିବ ଟେକ୍ ଅଫ୍ ହବ ଡିଲେ ଆପଣଙ୍କର ମିଷ୍ଟର ବାରିକ ମାନେ ସପୋର୍ଟ ଡିଲେ କଣ୍ଡନ କରିଦବା ଆଜି କଣ କହୁଛନ୍ତି
ଡିଲେ କଣ୍ଡନ ହବ ନାହିଁ
ଠିକ ଅଛି
ମୁଁ ଦେଇଛି ଆଜ୍ଞା ଅବଜେକ୍ସନ ଦେଇଛି ମାଇ ଲର୍ଡ
ଠିକ ଅଛି
ଦେଇଛି
No.
Mr. A.K. Behra for the petition RPFM 173 2025. Mr. R.N. Barik for the opposite party. The matter is taken up in VC. It is submitted by Mr. Barik, learned counsel for the opposite party, that he has filed objection to the IA seeking condonation of delay. Copy served, Mr. Behra.
No, my lord.
No, sir. Yes, my lord. Yes, my lord. I have submitted to Mr. A. Tripathi, his senior.
মানে WhatsApp আজকাল কোন WhatsApp না ফিজিক্যাল কপি দিলে কোড ହେଲା কোন কপি দিলে
ফিজিক্যালি মাই লর্ড মাই ফিজিক্যালি
আচ্ছা আউ মিস্টার বেরা কোন আপন I will it is submitted that stop it is also submitted the copy of the application has been copy of the reply has already been served. Stop. Mr. Behra, Lord Counsel, submits that he is unable to locate the said copy and he will verify. Stop. ଆପଣ ଆଉ ଗୋଟେ କପି ଦେଲେ ରିକ୍ୱେଷ୍ଟ କଲେ ଆଉ ଗୋଟେ କପି ଦେବେ ମିଷ୍ଟର ବେହେରା ସରି ମିଷ୍ଟର ବାରିକ
ମାଇ ଲର୍ଡ ୟେସ୍ ମାଇ ଲର୍ଡ
ହଉ if required the Lord Counsel for the
ଆଉ ଗୋଟେ କପି ଦେଇ ଦିଅନ୍ତୁ
Lord Counsel for the petitioner shall be provided with another extra copy of the objection by the Lord Counsel for the opposite party. Stop.
Along with my lord
shall be listed for the order. সেটা কেবে রাখিলে? The matter shall be listed along with RPFM 68 of 2025 in the week commencing on 30/6.
And also I pray my lord provide me RPFM 68 of 2025 one set extra copy.
So 68 লিখি দিও তুমি Mr. Barik সেটা নোটিস ইস্যু হেনি ଗୋଟେ কপি দিଅନ୍ତୁ that will help you
my lord সেটা কপি ମୁଁ ଦେଇଛି already my lord
68 ଦେଇଛନ୍ତି
ଆଜ୍ଞା RPFM 68
ମୁଁ ଦେଇଛି 272 ବି ଦେଇଛି to Mr. Senior Mr. A. Tripathi
okay
ତାଙ୍କ ସିନିୟର ତାଙ୍କୁ କିଛି ପଚାରୁ ନାହାନ୍ତି ଆଉ So Behra, your senior is putting you in trouble, as Mr. Barik says.
So, sorry, my lord, I will verify.
68 लिखो तो जो लिख लेनी कि Mr. A.K. Behra. Mr. Behra requests for an extra copy from the Lord Council. Request for an extra copy of the petition to be provided. Stop.
Yes, sir.
The Lord Council for the petitioner is requested to serve an extra copy. Line article. 38 ଆସିବ order sir. Now 38 ନା ତା ପରେ ଆସିବ?
ଆଜ୍ଞା first week of July, my lord. First week. ଆଜ୍ଞା ଆଜ୍ଞା।
ଜୁଲାଇରେ ରଖନ୍ତୁ।
We commencing 13
ଦିଲ୍ଲୀ ଯାକେ 13/7 କରିଦିଅ। We commencing 13/7।
ଆଜ୍ଞା।
Relation matter ଟା ମାଇଲର maintenance ଟିକେ shortly ହଉ ମାଇଲର।
Shorted ଆଜ୍ଞା।
ଆପଣଙ୍କର ତ ସେଇ ଯୋଉଟା ତ ଯାହାହେଲେ ବି ତ ଟେକ୍ ଅପ୍ ଆପଣ ଏକ୍ଜିକ୍ୟୁସନ ଫାଇଲ କରିଛନ୍ତି ତ ଅଲରେଡି ଅର୍ଡର ହେଇଛି ଆଉ ଆପଣ ତ ଜାଣିଛୁ you have been successful there।
ମାଇଲର।
ସେଇଟା ବି ଛୁଟି ପରେ ଟେକ୍ ଅପ୍ ହେଇପାରେ ଏବେ ଛୁଟି ଅଛି ହେଇପାରେ ଟେକ୍ ଅପ୍। ସେଠି ଦେଖନ୍ତୁ ସେଠି ଏକ୍ଜିକ୍ୟୁସନ ଟା ଫଲୋ କରନ୍ତୁ ମିଷ୍ଟର ବାରିକ।
ମାଇଲର ସେ ହ୍ୱାଟ୍ସଆପ ନମ୍ବର ଦେଲେ ମୁଁ ଦିଟାକୁ ପଠେଇ ଦିଅନ୍ତି। ତାଙ୍କ ହ୍ୱାଟ୍ସଆପ ନମ୍ବର ଦେଲେ ମୁଁ ପଠେଇ ଦିଅନ୍ତି କପି ଦିଟା ଯାକ।
ହ୍ୱାଟ୍ସଆପ ନମ୍ବର ତାଙ୍କର ଏଇ ଯୋଉ ଆପଣ ଯଦି ସେଠି ଯିଏ ଅଛନ୍ତି ଆପଣଙ୍କୁ ଅପରେଟ କରୁଛନ୍ତି ଭର୍ଚୁଆଲ କୋଡ ସେ ଓକାଲତ ନାମରୁ ଦେଖିକି ଦେଇଦେବେ ଆପଣଙ୍କୁ। ଆପଣଙ୍କ ଆସିଷ୍ଟାନ୍ସ କିଏ ଅଛନ୍ତି ସେଠି?
ମାଇଲର ଏଇଠି।
ହଁ କେସ ନାହାନ୍ତି ହଉ ତାଙ୍କୁ କହିବେ କହିଛନ୍ତି ହଉ yes yes
Item 7.
Item 7, am I audible, Lordship?
yes please.
Item 7, Lordship, I filed this RPFM challenging the order dated 11/3/2025 of the Hon'Ble Family Court, where the Family Court has erroneously given a maintenance of 6,000 rupees despite I have already deposited an one-time alimony in the previous order where the dissolution of marriage took place of 15 lakh rupees. So this
so kindly give the basic facts. So when this application was filed, which was allowed by the Learned Trial Court, the date of filing of application.
Date of the date of order also is 11/3/2025.
Filing of application, not date of order. When the application was filed by the opposite party, which you are challenging.
I have not annexed the application for filing that order.
So you have to, whenever you are arguing a revision, you have to come up with the pleadings and the dates.
Yes, Lord.
Oh.
But Lord, for passing this order, 11/3/2025, orders took place, and in between 1 year, the
there is some difficulty in getting your voice.
Application for section 125 was filed, Lordship.
So when the application was filed,
Lordship, application date I am actually have not annexed, and I'm not sure. I'll get.
So don't second guess it, because you're if you are not sure of the dates, please don't second guess it. Be sure of the dates.
Yes, sir.
After vacation.
Lordship, actually, one execution petition has been filed by the opposite party.
I'll pass orders if you deposit the entire amount due without prejudice to your rights and claims. So you have to deposit the entire amount. It's in the nature of a money decree.
Yes, Lordship.
Yes. Order 41, Rule 11.
But Lordship, one interim protection may be given.
Protection subject to
for the further hearing.
So you should have that instruction that you are depositing that money. What is the amount due? How much?
Yes, sir. Lordship, I'll take.
The problem is that you are not answering when this petition was filed and for which period the order is passed. So that is crucial. So if you have that instruction, you can deposit the money.
Also, I don't have that instruction whether the party is able to deposit the remaining amount.
So it can't be bargained. Trial court decree cannot be bargained at the wishes of the party. Please appreciate that.
Yes, yes. But Lordship, in the previous question, what you asked is that the application was made on 18/12/2023, Lordship, by the opposing party.
18/12/2023. Yes. So, date of order in this application?
Date of order 11/3/2025.
11/3/2025.
Yes, Lordship.
So, when the CP was filed seeking divorce?
12/3/2024, the order was passed.
When the CP was filed?
CP order?
Or not order, when the CP was filed seeking divorce?
Yes, Lord. Just
So, CP was filed in 2022.
Yes, sir.
The order dated 12/3/2024.
Yes, Lord. Yes, Lord.
So, when did you deposit the alimony?
Already deposited subsequent to the order, Lord.
Date. It can't be prior to the order. It has to be subsequent to the order. The date of deposit of alimony?
I'm not sure about the date, but the Lordship.
So, you have to be very sure.
Yeah, yes, sir.
You have to be very sure and with evidence.
Lordship.
So, one thing I can suggest, though this exercise you should have done. You must understand the jurisdiction, you must understand the jurisprudence also.
Right.
So, after 12/3/24, the day you have deposited the alimony, till that date, you have to pay the 125. This is 125 CRPC.
This is 125 CRPC also.
Okay. So, in the written statement, have you taken this stand that you are paying alimony on what date?
Yes, Your Lordship, I have taken my stand, but
show that from your written statement. Show that from your written statement.
Written statement is not attached.
The problem is that you, while arguing, you have to answer 5 questions. No document or no answer. So,
Lordship, if the remaining from the remaining,
no, it can't be. It can be a jugaad kind of thing.
Lordship.
But arguing cases by jugaad doesn't help. Jugaad is the appropriate word actually.
But Lordship, if after if in the remaining amount, if I'm depositing 25% of the remaining amount,
no bargain. I am not here to bargain. Decide you will bargain the civil court decree, and I will accept the bargain. Because that will not be judicial approach.
Right.
So you have to be clear in your approach that up to if you have paid the alimony, the day you have paid alimony, and from the date of filing of application till the date of payment of alimony, that much you can calculate and tell. But the problem is that you have nothing now to tell.
Lordship, let it come after vacation at least.
Okay. Mr. P. Jati for the petitioner. This is item?
Item 7, Your Lordship.
7. The petitioner before this court is the husband in the marriage. He seeks a revision of the judgment dated 11/3/2025 passed by the Learned Judge Family Court, Hon'Ble, in CRP case number 66 of 2023. Stop. The said application was filed by the wife in the marriage under section 125 of the CRPC, along with the minor daughter born from the wedlock, represented through her mother guardian, seeking 50,000 monthly maintenance. In the petition, the marriage between the parties as well as the birth of the daughter is mentioned. The pendency of the application under section 13(1) 1-A of the Hindu Marriage Act, that is CP number 8 of 2002 T, pending before the Learned Judge Family Court, is also mentioned. The opposite party husband is stated to be working in Navabharata Ventures, getting monthly salary of rupees 15,788.
In a contractual position also.
Contractual or permanent or chairman, that is not important. His salary is 15,000 is important.
Got it.
Apparently, after the decree of divorce was granted by order dated by judgment dated 12/3/2024, the opposite party has got married again. Stop. To seeking revision and in challenge to the order of the Learned Judge Family Court, it is submitted by the Learned Counsel for the petitioner that since the petitioner has paid permanent alimony of rupees though he is unable to tell the date of payment, the opposite party is not entitled for any monthly maintenance. Apparently, the opposite party wife has received permanent alimony of rupees 15 lakhs, 15, 00, 000. The challenge is under a misconception that the award has been made to the wife, whereas the order passed by the Learned Judge Family Court is very clear that the wife has not been directed to, the wife is not directed to be paid any maintenance. The daughter has been paid maintenance of rupees 6,000. The petitioner remains in default of the amount of rupees 6,000 towards the daughter from 18/12/2023 till date, that is 18/5/2026, 41 months होଉଛି ବୁଝିଲେ କି 42 for 41 months, which comes to 41 into 6,000. In view of the The learned counsel for the petitioner is apprised of the judgment passed by the learned by the Honorable Supreme Court in Samima Faruqi versus Sahid Khan, which extensively deals with the scope of interference by this court in revision. In orders passed by family court directing payment of maintenance under section 125 CRPC. Paragraphs 19 and 20. Stop. The learned counsel is also apprised the fact that the maintenance directed to be paid to a minor child is akin to a money decree. And to sustain the challenge, the entire amount has to be secured. The petitioner shall file affidavit how he will secure the amount for the matter to be taken up for fresh admission. Amount एत्ते कर देवे 41 गुणन 6000 6 पे 6 24000 2,46,000 बाबत. No case, Mr. Jati. And I don't know. I think that you are a little bit confused because it can't be purposeful that you said that the wife has got, so she is not entitled. Or you are serious in that?
One request from my side is, though the children is very minor and at a very small age, so the quantum of maintenance according to my income is very high. That is one that one request can be kept.
Any case law, any provision of law you are having?
So, Lordship, I actually can tell.
So don't argue common sense and nonsense. For a minor daughter, you are saying 6,000 is very high in today's world. That is not only that is nonsense, Mr. Jati. Always make the conversation between you and me a legally sustainable, legally nuanced. Because you started under the impression that Ajit, the wife is getting 6,000.
Because it can be look after my income, at least my income is very low, Lordship, and I have already
you have the luxury.
remarried.
You have the luxury. You have the luxury of having multiple families, Mister. That is the problem. You have married again. You might be having blessed with more children. So that luxury militates with your income. So it is not the fortune of the minor child.
Lordship.
If the minor child's
lower court has also appreciated in
so that's so you have to go look for some judgment law.
Yes.
Common sense akin to nonsense. That since I am married and I go on marrying and procreating children, so I should be saddled with less maintenance. A girl child 6,000 per month. What was your plea to give her? How much you decided to plea her to your child? Let us hear. Let us be serious in this. What was your plea in the written statement to pay to your daughter?
Lordship, I want to plead at least the mother should have also some responsibility because she is highly qualified and is capable.
Sir, that is again nonsense. That is again nonsense. That doesn't make any legal sense or common sense. The mother's, if mother is educated, the girl child is to be neglected by a father. How can he pass that order? You must understand.
I'm not denying any responsibility from my side, Lordship.
You are saying that you can look at your leisure what you are arguing in YouTube. You are saying that.
No,
that
so
since
I'm not denying this any responsibility, Lordship. I am ready.
Mr. Jati, that will create a situation where for your third marriage, the second child or the third child will be neglected.
No.
And you should not have argued that the wife is getting alimony because I took it seriously rather. But since I follow the simple principle of reading, so I realize that what you are arguing is not correct. What? Plea before the court that you will how much you will give to the daughter.
I need to take instruction, Lord.
Sir, that instruction you cannot take. Because that you have filed a written statement. What was your written statement? Denying liability or how much you wanted to the so that what was that?
We'll bring that.
This cannot be re-argued again. Supreme Court is very clear. As due payable to the minor child till date. So as so that this court can pass further orders. If at all to entertain the application.
Also, one case law, if I can cite, let's say one case law, if I can cite is that Bhushan Kumar versus Rajkumari.
Sir, where the 6,000 granted to the minor daughter has been denied?
It's not been denied, Lordship.
So please read fast, Lord Halsbury. Queen versus Latham.
Lordship.
That will clear your mind that you should not cite these decisions indiscriminately.
Yes, sir.
Citing a decision, the principle has been laid down in 1901. Language is very clear. The precedence is not what logically follows from that judgment. Because what you are now reading, you are reading only one line. That the wife as a mother has a responsibility. But your argument is that since the mother has responsibility, you don't want to give anything. Even you have not bothered to read the written statement, what you stated before the court, that how much you will pay.
No, I am not denying.
You are saying that you will obtain instruction regarding the written statement. Yes. So whatever next time you read with Queen versus Latham.
Yes.
1901 All England Law Reports. The appeal cases, it is also there. We have all read this. We have asked our senior to read because that will help us in citing decisions. Yes. The matters will be listed for fresh admission in the week commencing. 29
Oblige.
Na July. Kebe chahuchu?
29
ठीक है. Yes.
Oblige.
Item 8.
Item 8, my lord.
Yes, please.
Lordship may see the last order. My lord had directed me to take instruction as to whether I had secured the decretal amount of rupees 1,10,000.
Yes, you are saying that he is not responding.
No, my lord. Now, my lord, I had instructed my client. Now, accordingly, my lord, I came to know that his father is suffering from brain stroke. Upon my insistence, he has paid my lord 16,000.
से अर्जुन कर दूची तां कोन तो आप किछि देबे तापर देखिबा.
My lord, I am sharing the postal money orders detail, my lord.
If you are convinced, so instead of money order, actually these things are become cumbersome. Ask him to deposit in UPI or directly to the amount where the child can receive. Maybe the mother will receive or something, or guardian, whoever.
Only mother, my lord.
So you ask him to credit directly by UPI or IMPS. Those instant mode of transmission.
Yes, my lord. I will ask him, but he has already paid 16,000 through money.
But the due was Mr. Mahapatra 1,10,000.
1,10,000, my lord.
So at least allow him to achieve something. You are saying he is distressed, so let him reach at least 50,000.
My lord.
Mr. S.S. Mahapatra for the petitioner. Let item 8.
8.
Learned counsel for the petitioner refers to the earlier order dated 17/4/2026 and the order prior thereto dated 23/2/2026. Stop. So far it is submitted that the petitioner had some difficulty due to ailment in his family, and he has deposited rupees 16,000. He has deposited he has given 16,000 by money order to be received by the which has by money order to the wife Kapam Patel to the wife opposite party. Stop. Noting the positive development, the matter is adjourned. The petitioner is granted further time to deposit further amount in view of the fact that the total amount due as on author of on 17/4/26 was 1,10,000. Stop. The matter shall be listed for fresh admission in the week commencing 27. ଏତେ କ'ଣ ଆଇଏଟା କ'ଣ ପାଇଁ ଅଛି?
Lord, stay of operation of order.
Execution ଅଛି?
Execution they have filed, my lord, recently. CRP number 125 of 25.
ଠିକ ଅଛି। ଆପଣ ଆଉ 30,000 ଦେଇପାରିବେ?
I will take instruction, my lord. I will instruct him to pay, my lord, because he has to pay.
Okay. IA 409 of 2025. It is submitted by the Learned Counsel for the petitioner that execution number out there koibe
125 of 2025. After
execution 125 of 2025 arising out of judgment dated 25/6/2025 in CRP number 08 of 2025.
24 man. 24 man.
भूल गए 392
8 में 25 सर CRP
हाँ 24 ना 25
25
ଆପଣ 25 ବୁକ୍ ଠିକ କହୁଛନ୍ତି ନା ଆପଣ ଠିକ
ପାଇଲଟ 25 ମିନିଟ୍
25 ତ ଠିକ ଅଛି ନହେଲେ ସେ ଅର୍ଡରଟା ଭୁଲି ଯିବ କ'ଣ ଲେଖି execution ଏତେ arising out of CRP ଏତେ is pending before the Learned Judge Family Court.
ପାଇଲଟ ଫୁଲବାଣୀ
stop. এটা কেবে কো আপন রাখলে 27 को रखছো 27 ঠিক আছে in the interim it is directed that the said execution case shall be adjourned to a date beyond 20 state court to 27/7/2026 as would be convenient to the Learned court in season of the matter. Stop. They stop now upon a prayer being made for the said purpose. The petitioner shall do well to deposit further amount towards the pending towards the maintenance due. Further amount towards the maintenance due. Because at least you have been partly successful in your approach.
My lord.
Yes. That so this leads to a very rather a just and equitable situation.
Sir.
If you are present in the earlier matter, the minor child is granted 6,000, that is not being paid. So we have a kind of a responsibility to well.
My lord, the order has to be honored.
Yes. To some extent, actually, the attitude has developed that they will be driven to destitution and vagrancy. Matter is kept lingering, which is also several times highlighted by Supreme Court. In Rajneesh, they have said that 7 years it is kept pending. That particular Rajneesh versus Neha matter. Yes. Next.
Item 9.
Mr.
In
Samir,
item 9, Your Lordship.
Yes, please.
Your Lordship, remembers, Your Lordship directed that they should tell the date when they will appear in the trial court, because Your Lordship remembers.
Right.
There was a direction.
So that it can be closed.
Yes, because the petition will be considered after her appearance. That was the direction of the trial court. But trial court has closed the petitions also because of non-appearance, her non-appearance.
No, already appearance.
So,
Appearance.
after getting the Bhokaladana, we have entered appearance today.
No, my lord, in the
ନାଇଁ,
trial
ସେଥିରେ
court,
କୁହନ୍ତୁନି ଆପଣଙ୍କ appearance କଥା ପଡିନି.
After vacation on 21st June.
Dismiss ଶୁଣନ୍ତୁ ଶୁଣନ୍ତୁ ସେମିତି କରନ୍ତୁନି. ଆପଣଙ୍କର appearance is not important. Appearance of the party is important. ଆପଣ every time କାଲି ଆଉ ଜଣେ ଆସିବେ ତା ପରଦିନ ଆଉ ଜଣେ ଆସିବେ ସେମିତି ତ ହବନି. ଆପଣ କେବେ appear କରିବେ କାଲି କହିବେ.
After let it be taken up after vacation.
ଆରେ ଆପଣ ବୁଝି ନାହାନ୍ତି କେସଟା. ଆପଣ ପଢିବେନି ବୋଲି ତା ମତେ ବାଧ୍ୟ କରନ୍ତୁନି ଯେ ମୁଁ ନ ପଢିଲା ଭଳି ଆକ୍ଟିଂ କରିବି. ବୁଝିପାରୁଛନ୍ତି? ଆପଣ କେସରେ ଯାହା ବି ଆପଣ 26 ତାରିଖରେ କରିବେ ସେଟା କାଲି ବି ହେଇପାରିବ. ଏଥିରେ କିଛି ପ୍ରିଡିକ୍ସ ନାହିଁ.
କଣ କହିଲେ କୁହ?
ଶୁଭୁନି ଆପଣଙ୍କ କଥା ମୋ କଥା? ଆପଣ କେସରେ ଜିତିଗଲେ ଶୁଭୁଛି?
ସାର୍ ମୁଁ ଟିକେ
ବର୍ତ୍ତମାନ ଯେମିତି ଶୁଭୁଛି ଜିତିଗଲେ ସେମିତି ଶୁଣନ୍ତୁ. ଆପଣ ଆଜି ଇନଷ୍ଟ୍ରକ୍ସନ ନେବେ କାଲି କହିବେ କେସ୍ ଆସିବ କୋଉ ଦିନ ଆପିୟର କରିବେ କୋର୍ଟରେ କହିବେ କାଲି.
ଆଫ୍ଟର ଭ୍ୟାକେସନ
କରିହବନି.
ପିଲାଟାର ପରୀକ୍ଷା ଅଛି ନିଟ୍ ପରୀକ୍ଷା ଜୁନ।
ଆଜ୍ଞା ପିଲାଟାର ନିଟ୍ ପରୀକ୍ଷା ବର୍ତ୍ତମାନ କ୍ୟାନସଲ ହେଇଗଲା ତେଣୁ ଆଉଥରେ ବି କ୍ୟାନସଲ ହବ ସେଇଟା ଅଲଗା ଜିନିଷ. ନିଟ୍ ପରୀକ୍ଷା ପାଇଁ ମୁଁ ଆର୍ଜନ କରିପାରିବିନି.
ପିଲାକୁ ଛାଡିକି ତମେ ଆସିପାରିବନି ନା?
ଆଜ୍ଞା ଛାଡିବା ଦରକାର ନାହିଁ. ଆପଣ ଛଡେଇବେ ନା ମୁଁ କାହିଁ ଛଡେଇବା ପାଇଁ କହିଲି କି? ଆପଣ କାହିଁ ପିଲା ପାଖରୁ ଛଡଉଛନ୍ତି ମାକୁ? ପିଲାକୁ ମାକୁ ପିଲା ପାଖରୁ ଛଡେଇବା ପାଇଁ ଆପଣ କିଏ କହିଲା ନିଟ୍ ପରୀକ୍ଷା ବେଳେ?
ଆଫ୍ଟର ଭ୍ୟାକେସନ।
ଆରେ ଆଫ୍ଟର ଭ୍ୟାକେସନ ମନ୍ତ୍ର ନୁହଁ ଆଜ୍ଞା. 10 ଥର କହିଲେ କଣ ସନ୍ତୁଷ୍ଟ ହେଇଯିବେ? ଆଫ୍ଟର ଭ୍ୟାକେସନ ଟା ଗୋଟେ ମନ୍ତ୍ର ନୁହଁ.
Now, my learned senior is possibly failing to make a distinction that your lordship want a statement from the wife as to when he will appear. Your lordship is not saying that she will appear before vacation.
Your lauded senior, because understand that he's saying about NEET and doing the chanting mantra of after vacation. Because he understands. କାଲି ଆସିବ ନହେଲେ କାଲି ଫାଇନାଲି ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଯିବ ହେଲା.
ଛୁଟି ଅଛି
କାଲି ଛୁଟି ନାହିଁ କାଲି କୋର୍ଟ ୱାର୍କିଂ ଅଛି. ନାଇଁ ଆଜ୍ଞା ହେଇପାରିବନି. ଆପଣ ଯୋଉ ଚେଷ୍ଟା କରୁଛନ୍ତି ମାକୁ ଛୁଆ ପାଖରୁ ଅଲଗା କରିବା ପାଇଁ ସେଟା କରନ୍ତୁନି. ଆପଣ ଯେମିତି ଆପଣ କୋଉ ବେସିସରେ ଆପିୟର କରିଛନ୍ତି?
ଛୁଟି ହେଇଯାଉଛି.
ଭଲ ହେଇଛି.
ଭ୍ୟାକେସନ ପରେ
ସେଥିପାଇଁ ମତେ ସୁବିଧା ହବ ଅର୍ଡରଟା କାଲି ପାସ୍ କରିବା ପାଇଁ. ଆପଣ ବୁଝିପାରୁନାହାନ୍ତି. ଆପଣ ସେଟା ପ୍ରଶ୍ନଟା ବୁଝିଲେ ହବ. ଆରେ ଆପଣ ଯଦି ଏମିତି ହେବେ ଗୋଟେ 1 ଡାଇମେନ୍ସନାଲ ମନ୍ତ୍ର ଭଳିଆ ଚାଟ୍ କରିବେ. You have to obtain instruction. ଛୁଟି ଖୋଲିଲା ପରେ ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ କୋଉ ଦିନ ଆପିୟର କରିବେ କାଲି ଆପିୟର କରିବା ପାଇଁ କୁହାଉଛି କି? ନିଟ୍ ପରୀକ୍ଷା ସରିଯାଇଥିବ ଏବଂ ନିଟ୍ ପରୀକ୍ଷା ଯଦି ବି ଆଉ ହବାର ଥିବ ବି କିଛି ଅସୁବିଧା ନାହିଁ. ତୃତୀୟ ଥର ହବ.
ଜୁନ 25 ଜୁନ ସେକେଣ୍ଡ ଲାଷ୍ଟ ୱିକରେ ସେ ଆପିୟର କରିବେ ଆସିକି.
ଆରେ ସେଇଟା ତ ଆପଣ ଗୋଟେ ଷ୍ଟେଟମେଣ୍ଟ ଗୋଟେ ମେମୋ ଦେବେ ଲେଖିକି ଦେବେ. ଟେଣ୍ଟାଟିଭ ହେଇପାରିବନି. ଆପଣ ଟେଣ୍ଟାଟିଭ ମୁଁ କିନ୍ତୁ ଟେଣ୍ଟାଟିଭ ନୁହଁ ନା.
ପଚାରୁନି ସାର୍ ତାକୁ 25
ଆଜି ପଚାରନ୍ତୁ ଆଉ ନିଟ୍ ପରୀକ୍ଷାରେ ବେଶୀ ଡିଷ୍ଟର୍ବ କରନ୍ତୁନି. ସେ ତାଙ୍କ ପିଲା ପାଠ ପଢୁ. ଆପଣ ଯୋଉ ପ୍ଲାନ କଲେଣି ତାକୁ ଡିଷ୍ଟର୍ବ କରୁଛନ୍ତି ଡାକୁଛନ୍ତି ସେମିତି କରନ୍ତୁନି.
25 26
ଦି ଦିନ କେମିତି ହବ ଆପିୟରାନ୍ସ? କ୍ୟାଲେଣ୍ଡରରେ 25 ଗୋଟେ ଦିନ 26 ଅଲଗା ଦିନ. ଆଉ 25.5 ପଢେଇ ପାରିବ କି? ନା କାଲି ଆସିବ ଆପଣ ତାଙ୍କ ସାଙ୍ଗରେ କଥା ହୁଅନ୍ତୁ. ଆପଣ ଶୁଣନ୍ତୁ. This much I can help you. Last time I gave an indication that I will allow you that time. Mr. Mishra realized that and he said that perhaps my lord is thinking. So in fact that is my thought. He is not opposing that. You may be scared of Mr. Mishra but he is not opposing. Because ଆପଣଙ୍କ ଚଏସ ରେ ଗୋଟେ ଡେଟ୍ ଅଫ ଆପିୟରାନ୍ସ କୁହନ୍ତୁ ଆପିୟର କରନ୍ତୁ. ସେଟା ସେଥିରେ ଭଲ ଅର୍ଡର ହେଲା ବୋଲି ସେ ଆର ଓକିଲଙ୍କୁ ଚେଞ୍ଜ କରିଦେଲେ. ଆଜି ଭଲ ଅର୍ଡର ହେଲା କାଲି ଆପଣ ଚେଞ୍ଜ ହେଇଯିବେ. ବୁଝିପାରୁଛନ୍ତି? ଆପଣ ଗୋଟେ ସିମ୍ପଲ କାମ ଆପଣଙ୍କର କନଭିନିଏଣ୍ଟ ଡେଟ୍ ଗୋଟେ କୁହନ୍ତୁ. ଦ୍ୟାଟ୍ ଆଇ ୱିଲ୍ ପରମିଟ୍ ୟୁ ରିଜନେବଲି. ଆପଣ ଯଦି ଅନରିଜନେବଲ କହିବେ ମୁଁ ଆର ବର୍ଷ ଆପିୟର କରିବି ଡିସେମ୍ବରରେ ସେମିତି କଣ ହବ? ଆପଣ ଯୋଉଟା କହୁଛନ୍ତି ଲୋଅର କୋର୍ଟ ଭେକେସନ ସେଟା କଣ ମୁଁ ଜାଣିନି? ଛୁଟିର ଆରେଞ୍ଜମେଣ୍ଟ ଆଜ୍ଞା ଆମେ କରୁଛୁ. କିଏ ରହିବ ରୋଷ୍ଟରରେ ଆପଣ କହିବେ ଛୁଟି. ଆମେ ଅବଭିୟସଲି ଆଇ ଅଣ୍ଡରଷ୍ଟାଣ୍ଡ. ଆପଣଙ୍କର କାମ ହେଲା ଆପଣ ଫାର୍ମଲି ଗୋଟେ ଫାର୍ମ ଡେଟ୍ ଦିଅନ୍ତୁ. ଛୁଟି ପରେ ଦିଅନ୍ତୁ କିଛି ଅସୁବିଧା ନାହିଁ. ଆଉ କେତେ ଅଧିକା ମୁଁ କହିପାରିବି? କାଲି କୁହନ୍ତୁ. Don't take a chance. don't take a chance also. You talk to the person or the learned counsel who is appearing. You did not disturb. Can I tell you case nahi? Simple, it is only for appearance and statement. It is a strange case that your client is not appearing. You have to use your good offices. You have to counsel.
Yes.
Kali asu, kala? Simply adjourn tomorrow. Please take that instruction. Na aji pass over kale chalibo.
Tomorrow. Yes, ma'am. Tomorrow. Like
Kali say aji ja position aji share hoibo. It will written. Please get that instruction.
ଗୋଟେ ଏଣ୍ଟ୍ରି ମର୍ଡର ଥିଲା ଯେ ସେଟା କାଲି ବି ପାସ୍ କରି ହବ ଏଣ୍ଟ୍ରି ମର୍ଡର ଥିଲା ସେଟା କାଲି ପାସ୍ ହବ
କାଲି ହବ ସେଟା ବି ମିଷ୍ଟର ମିଶ୍ର ଇଜ ଆଗ୍ରିଏବଲ୍ ଆପଣ କାଇଁ ଡରୁଛନ୍ତି ତାଙ୍କୁ ସୋ ପ୍ଲିଜ ଟେକ୍ ଦ୍ୟାଟ୍ ଇନଷ୍ଟ୍ରକ୍ସନ କେବେ ଆପିୟର କରିବେ ସରିଲା କେସ୍ ଇଜ ଓଭର ଆପଣ ଯାହା ସେଠି ହବା କଥା ହବ କାହିଁକି ଆପଣ ପେଣ୍ଡିଂ ରଖୁଛନ୍ତି ଏଠି ୟେସ୍ କାଲି ଡେଟ୍ କରିଦେବେ ନା
ମାଇଲର
Tomorrow is physical also. ଆଜ୍ଞା ବେହେରା ଥିଲେ ପଳେଇଲେ କୁଆଡେ ଆଚ୍ଛା ତାଙ୍କର ସରିଗଲା ସେଟା ସେ ବିକେ ବେହେରା ୱାନ୍ ଥିଲେ ଇଏ କଣ ବିକେ ବେହେରା କିଏ item 10 the matter hybrid mode लिखिए the matter is taken up in VC non-appears for the matter is taken up in VC virtual court stop on 29/4/2026 the matter was adjourned by the learned proxy counsel on behalf of the learned counsel for the petitioner. Stop. On the said date, the matter was listed after the registry had intimated the listing of the matter, that is 29/4/2026, as on earlier date 30/3/2026 none had appeared for the petitioner. On 17/3/2026 the matter was heard at length. The relevant facts as well as the legal issues were noted. The total amount due till March 2026 comes to rupees 2,70,000, which remains in arrear as the petitioner has not complied with the order, complied with the judgment passed by the learned judge Family Court Bhadrak, dated 28/2/2025. To grant a last opportunity to the petitioner, the matter shall be listed on for orders in the week commencing for fresh admission in the week commencing 13/7/2026. Yes, next.
Item 12.
ତାଙ୍କୁ message କରନ୍ତୁ.
May I please, Your Lordship?
Yes, please.
Item 12.
Yes, please.
May I please, pursuant to Your Lordship's order dated 3/2/2026, I have filed the affidavit in proper format. 30/4/2026.
MS Sonali Ponda for the petitioner, the Praveen Das for the opposite party.
My lord, may see the last two orders. Lordship has directed to tell it in the affidavit what is the amount they have paid and what is the amount due. But in this affidavit, what they have said is only the amount they have paid. The outstanding amount till today, my lord, is around 6,60,000. And in the present case only, the balance amount is 85,000. But they have not said anything about the balance amount, what is to be paid. And this is for the second time they are filing this affidavit. On the first occasion, Lordship has said that this affidavit is not in order.
That affidavit is at flag L.
Yes, my lord. On the last occasion, they have filed.
When the order was passed?
My lord, the
On
order.
3/2/2026.
Sorry?
On 3/2/2026.
2/2026. Prior to that,
prior to that also.
3/1/2025, or you have only paid?
The order in this petition, the order is on the challenge. We are in that case we are paying regularly.
No, not true.
As per my instruction,
You look at your affidavit. Don't speak from your mind and from your instruction. ଆପଣ affidavit ଟା place କରନ୍ତୁ.
in this petition we have challenged the
Affidavit, payment affidavit.
affidavit we have filed on 30/4/2026. In that we have mentioned that
Flag L ରେ ଯୋଉଟା ଅଛି
yes,
30 April.
Melody in item number 2 of the affidavit, Lordship may kindly page 2.
ଆପଣଙ୍କର ଅଡିଓ ଟା actually problem ହେଇଯାଇଛି.
ଆଚ୍ଛା କଣ ଦେଖ ଶୁଭୁନି
ଚଡଚଡ ହଉଛି.
Your Lordship may take it after vacation better.
My lord, I object, my lord, on this ground only, my lord, that they
Stay
have
ଅଛି stay ଅଛି ନା କଣ?
is not there, but they are not paying anything, any amount, my lord. The amount is, my lord, 6 lakhs.
So you go for execution if there is no stay.
The execution is also there. Multiple execution application is also pending. And unfortunately, my lord, they are taking the stand in paragraph number 6. That is the most unfortunate part, my lord. In para 6, the petitioner is stating that the wife has been reinstated in service. The wife was a SI of police, my lord, and he has been reinstated in service. That is their stand. But
yes,
fact remains,
whatever whether
that is a false
reinstated or
statement
not.
also.
So that has not impressed the court because we are only on that maintenance amount Whether she is DG of police or SI of police, that is not important.
My lord. She is not working at that.
Mr. Das, if the trial court would have said that since he is SI of police not entitled to maintenance, that's a different thing. We are not there. We are just
The balance amount, my lord, that is the total amount has not been.
In this case, 5,000 has been awarded, and we are paying 5,000 regularly.
So if you pay regularly 5,000, the amount will be much more.
Much more.
You have not paid. You
No,
can look at kindly. So look at your affidavit what you have filed. That affidavit, the place it that because the amount would be much more, because I could not also understand that affidavit.
My lord,
5,000, Madam Das, 5,000 from the date.
Yes, 5,000. My lord, it was the order was from 3/1/2025.
14/3/24.
3/1/2025.
No, not 3/1. Because I have checked that order, because that order is prior to 3/1/25.
No, my lord,
Section 24.
Let me do.
Section 24.
My lord, 3/1/2025. Your lordship may kindly
No, that is not the order. That is not the order.
My lord, your lordship may kindly come to page 23 of my petition.
Oh, should I repeat it? No, it's like seat out there.
Section 24 application was allowed. Earlier, her application in the 125 proceeding was rejected.
So, what is the date of application of 14/3? 14/3/24.
23/24.
So that is the date. So that is the date.
13/9.
From 14/3/24 till 14/3/26, it comes to 1,20,000.
Yes. My lord, your lordship may
14/3/24 ରୁ ଆପଣଙ୍କର ଆଟଲିଷ୍ଟ 14/3/26 ଯାଏ ହବ 24 ମାସ 5,000 ଲେଖାଏଁ।
My lord,
5,000 ଟା ଅଛି।
5,000 ତ 1,20,000 ସିମ୍ପଲ ହଉଛି 1,20,000।
5,000 ଲେଖା ଅଛି। ତା ଦେହରେ ଆପଣ ଟିକେ ଦେଖନ୍ତୁ ପେଜ 24 ର last para.
Yes.
Peru the case record, the petitioner husband has filed this case against the respondent wife for the division of their marriage. In the both petitions, the respondent has alleged about non-payment of interim maintenance and amount past so and so. She has filed execution so and so. Then your lordship may no order for interim maintenance has been passed in this case. I found strength in the submission of so and so. The respondent has filed this petition. Stand rejected. Rejected, and I have been directed to pay rupees 5,000. Actually, I am not. Area is pending.
Area 14/3/24 ରୁ 14/3/24 ରୁ ଆପଣଙ୍କର ହଉଛି ଆପଣଙ୍କର ଆଫିଡେଭିଟ ରେ ଆପଣ ବି ଯୋଉ ଲେଖିଛନ୍ତି କିଛି ବୁଝା ପଡୁନି।
ନାଇଁ 14/3/24 ନୁହେଁ 13/9/24 ରେ ସେ ଫାଇଲ କରିଛି।
13/9/24 ରୁ।
ହଁ 13/9/24 ରେ ସେ ଫାଇଲ କରିଛି ଫର
କେସ୍ ବିଟର ଦା 14/3/24 ଆଉ 13/9/24।
13/9/24
that is in the order.
ନା ଆପଣ ଅର୍ଡର ସିଟ୍ ଦେଖିଲେ ଲାଗୁଛି 14/3/24।
At page 33 also it is there. Page 30.
ଆପଣଙ୍କର ଅର୍ଡର ସିଟ୍ ଦେଖିଲେ ଲାଗୁଛି ସେଟା 14/3/24।
14/3/24।
So it comes to 24 ମାସ ହେଲେ 120 plus another 10,000 ହେଲେ 130.
ହଁ ମୁଁ ତାକୁ ଦଉଛି ବର୍ତ୍ତମାନ ଯାଏ ଦେଇଛି 40,000 in that case.
ଆପଣ 90,000 ଦିଅନ୍ତୁ 90,000 ଦିଅନ୍ତୁ କି ଆଟଲିଷ୍ଟ ସେଇ ଯୋଉ ଅର୍ଡର ହେଇଥିଲା ସେଇ ଅର୍ଡର ଯେ 80,000 ମାନେ ଦିଅନ୍ତୁ 90,000 ନହେଲେ ନାହିଁ ଆପଣ ଯେବେ ଆପ୍ରୋଚ କଲେ ହାଇକୋର୍ଟକୁ ଅର୍ଡର ହେଇଥିଲା 80,000 ଦେବେ ଆଉ 10,000 ଛାଡନ୍ତୁ
ଅଲଗା କେସରେ ମୁଁ ଦଉଛି ବି 6,000 କଣ ଡୋମେଷ୍ଟିକ ଭାয়োଲେନ୍ସ କେସରେ ତ ଏଟା ମର୍ଜ କରିଯିବ ନା
ସେଇଟା ମର୍ଜ ସେଠି କରେଇଥାନ୍ତେ ମୁଁ ମର୍ଜ କରିପାରିବିନି ମୋର ଅଥରିଟି ନାହିଁ ଆପଣଙ୍କର 12,000 କି 20,000 ଜାଗାରେ 6,000 ହେଲା ଆପଣ ଯଦି ସେ ପ୍ଲିଟା ନେଇଛନ୍ତି ସେଠି ସେ 6,000 କୁ 12,000 ହେଇଥାନ୍ତା 6,000 ହେଲା ସେଟା ଆଇ କ୍ୟାନଟ୍ ମର୍ଜ ଇଟ୍
ମୁଁ ସେଇଟା କହୁନି ମୋର କହିବା
ଆରେ ଆପଣ ସେଟା କହୁନାହାନ୍ତି ମୁଁ ସେଟା କହୁଛି ଆପଣ କହିଲେ ଯେଟା ମର୍ଜ ହେଇଯିବ ଯୋଉ 6,000 ସେ 6,000 ଟା ସେ କୋର୍ଟ ଯିଏ ଡାଇରେକ୍ସନ ଦେଇଛନ୍ତି ତାଙ୍କୁ କହିଲେ ସେ ମର୍ଜ କରିବେ
ଠିକ ଅଛି କିନ୍ତୁ
ଆପଣ ଯଦି ସେ ପ୍ଲି ନେଇଥିଲେ କି ଡୋମେଷ୍ଟିକ ଭାয়োଲେନ୍ସ ରେ
ଡୋମେଷ୍ଟିକ ଭାয়োଲେନ୍ସ ରେ ଆମେ ନାଇଁ ଡୋମେଷ୍ଟିକ ଭାয়োଲେନ୍ସ ରେ ଆଗେ ହେଲା ତାପରେ
ଏକ୍ସାକ୍ଟଲି ଆପଣଙ୍କର 24 ଧାରା ପିଟିସନ ରେ ସେ ପ୍ଲିଟା ନେଇଥିଲେ କି ଯେ 6,000 ପାଉଛନ୍ତି ବୋଲି ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟ ରେ ହଁ ତାହେଲେ ଠିକ ଅଛି ଦେ ହ୍ୟାଭ୍ ବିନ୍ ଟେକନ୍ ନୋଟ୍ ଅଫ
ନାଇଁ ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟଟା ତ ମୁଁ ଏଠି ଫାଇଲ କରିନି
24 ରେ ଅବଜେକ୍ସନ 24 ରେ ଆପଣ ଅବଜେକ୍ସନ ଫାଇଲ କରିଥିବେ କି ରିଟନ୍ ଷ୍ଟେଟମେଣ୍ଟ କୁ ଯାହା କରିଥିବେ so if you can always file that modification but whatever but I cannot modify that by adding the domestic violence
ସେଠି ଲେଖିଛୁ 31 ପେଜ 31 ଟା ଟିକେ ଦେଖନ୍ତୁ
ଆପଣ ପଢୁନାହାନ୍ତି
ଆଜ୍ଞା
31 କୁହନ୍ତୁ କଣ ଲେଖିଛନ୍ତି
31 ପେଜ
କୁହନ୍ତୁ ପଢନ୍ତୁ
ହଁ ପେଜ 31 ରେ ଲେଖା ହେଇଛି It appears from the disclosure statement of the petitioner number White that she is 31 years so and so. The date of marriage is so and so. However, the date of separation has left blank. She has admitted about passing of the order for payment of ₹6,000 per month in favor
so it has been taken account 12,000 ହେଇଥାନ୍ତା ନହେଲେ
ମୁଁ ତାକୁ ଆପଣ ଏଟାକୁ ରଖନ୍ତୁ ଆଫ୍ଟର ଭ୍ୟାକେସନ
ଆପଣଙ୍କର ସେ ଯୋଉଟା ଯଦି ସେ ପ୍ଲି ନେଇଥାନ୍ତେ ନେଇ ନଥାନ୍ତେ ଅଲଗା କଥା ଯଦି ନେଇଛନ୍ତି ଇଟ୍ ହାଜ୍ ବିନ୍ ଟେକନ୍ ଆକାଉଣ୍ଟ ସେ 12,000 କି 15,000 ଜାଗାରେ ସେ 6,000 ଆଡଜଷ୍ଟ କରିକି 6,000 ଦେଇଛନ୍ତି
ମୁଁ କିନ୍ତୁ ଗୋଟେ ଆପଣଙ୍କୁ ପ୍ରେୟାର କରୁଛି ଯେ if the matter is sent for mediation
I cannot for payment of money I have to reject that prayer
ଆଜ୍ଞା
I have to reject that prayer. I'm recording my reasons and rejecting that prayer for sending to mediation for payment of maintenance.
No, not for payment.
ଆପଣ ପେମେଣ୍ଟ କଲା ପରେ ମେଡିସିନ କୁ ଯାଆନ୍ତୁ
ପେମେଣ୍ଟ କଲା ପରେ ଆଉ ମେଡିସିନ
ଆପଣ ଏଟା 2 ମାସ ହେଲା ମେଡିସିନ ପାଇଁ କହୁଛନ୍ତି 2 ମାସ ହେଲା ବି ମୁଁ କନସିଷ୍ଟେଣ୍ଟଲି ମୁଁ when amount is due I cannot direct for mediation.
May I pray your lordship may consider my case and pass the order.
Yes it will be hard so execution is stayed by this court Mr. Das
No, no.
So you go ahead with execution
yes
hard Mrs. MS Sujata Jena along with MS S. Ponda for the senior advocate along with MS S. Ponda for the petitioner. So Praveen Das for the opposite party. Order para 1, para 2. Or 21-2026. The following order was passed. Para 3 ta quote करते हैं. Thereafter, the matter has been adjourned repeatedly. At the instance of the petitioner, by order dated 6/3/2026, 6/3/32 ago. (3/2/2026). on 6/3/2026 order ta quote kar de 31/3/2026 27/4/2026 the matter is taken up in virtual court today. The Lord Senior Counsel refers to the order detailed to the affidavit filed on behalf of filed by the petitioner dated 27/4/2026, which indicates that amount of 40,000 has been paid. Which does not indicate how much amount exactly has been paid pursuant to the order passed by the Lord Judge Family Court in section 24 of the Hindu Marriage Act. Dated order date, Mr. Das given? Misconduct, 24 order ta?
My lord, 24 order passed in 3/1/25.
3/1/2025.
3/1/2025. With effect from the date of filing of application under section 24 of the Hindu Marriage Act, dated 14/3/2024. It is not disputed by the learned counsel for the petitioner as well as the learned instructing counsel for the petitioner as well as the opposite party that the total amount paid under section as directed by order dated 3/1/2025 in the pending CP that is directed to be paid from the date of application dated 14/3/2024. Total amount kete payment heichi?
40,000.
Lord, as per my
40,000.
instruction,
In that-
it is 34.
84,000.
34,000 for my instruction.
40,000.
34,000 as stated by the learned counsel, Mr. Das from the project party, and 40,000 as stated on instruction by the learned counsel, Mrs. Konda of the petitioner. The learned senior counsel submits that the amount of rupees 6,000 directed by the domestic violence by the court in the domestic violence case number dash has not been accounted for while directing the payment of incidental light maintenance under section 24 of the Hindu Marriage Act. Stop. The result of the order sheet indicates that the Lord Judge Family Court has taken note of the payment of rupees 6,000 as directed in the DV case. Number of okay, DV case dash. Stop. The payment of parental light maintenance during pendency of a petition under section 24 of the Hindu Marriage Act has been elaborately dealt with by the Honorable Apex Court in Rajneesh versus Neha. Citation given, paragraphs dash dash paragraph so and so are opposite and applied herein. The paragraphs from the SEC print is reproduced herein. It is conclusion part of submission. It is submitted by Mr. Das, Learned Counsel for the opposite party that during pendency of the CP, despite the direction of the court to pay maintenance parental light under section 24 of the Hindu Marriage Act, CP 246 the amount is not being paid in one pretest or the other. It is submitted that at paragraph 6 of the এটা কে জব করি যাଉଛି স্ক্রিনটা এনলার্জ করতে হবে paragraph 8 କହିଲେ 8 କହୁଛନ୍ତି ଆପଣ ମିଷ୍ଟର ଦାସ ଆପଣ 8 ସେଟ୍ କରୁଛନ୍ତି
paragraph 6
paragraph 6 of the application it has been stated wrongly that the opposite party wife has been reinstated as a sub-inspector of police. Page 5 kuchandi. Page 5, Mr. Das.
Hello. Page 5, last paragraph, last portion.
Last. Stop. Consider due of this court, the amount of rupees 6,000 directed by the Land and Judge Family Court towards maintenance pending light as is just and proper as it has taken note of the amounts already paid by the petitioner hearing husband to the opposite party wife. The daughter stays with the father.
No, my lord, mother.
The minor daughter born from the wedlock stays with the mother. Present opposite party. Stop. Regarding scope of interference of this court in exercising jurisdiction under Article 227 of the Constitution of India. Following has been laid down by the Honorable Apex Court in the latest decision data dated. So and so. It may myself keep myself. But in view of the above discussions, the writ application being devoid of merit fails and is dismissed. Yes.
My lord, may I submit?
Yes, please.
My lord, I have filed the detail in 25 to 2026 an affidavit. Entire order sheet I have filed. I have started paying from 8/9/2025.
Hey, you are getting confused. I don't know whether Mrs. Ponda and Mr. Das
that is there on record.
No, you have to listen to understand.
25 to 26.
All three of you are maybe confused, but I am not confused. My question is very simple.
I am also
you have to
not
listen to understand. You have to listen to understand. Kindly listen, then you will understand. You might have paid 10 lakhs or 15 lakhs. I am not disputing. I am not there. The question is that after the order is passed under section 24, how much is paid towards that? It is very simple. That is how it comes to 1,20,000. Otherwise, whether by paying 20 lakhs you will not pay 1,20,000 or that's a different thing. Because that's not the case we are adjudicating.
Now I want to clarify that 5,000 has been directed to be paid.
You are not getting. Please let us not repeat what we have already discussed.
No,
please listen, madam. Please listen, then you will understand. By speaking, you cannot understand. Out of 5,000, you are saying you have paid 40,000. He says 34,000.
Kindly bear with me for a moment. Out of 5,000, I am paying 6,000.
Instead of making a speech, madam, kindly look at the affidavit. I have gone through the affidavit. Both affidavits that does not show that after the order in dated 1/5/31/2025.
Probably move
3/1/25.
Probably move clear होनी मोर कहिबा
You are so clear that I am able to immediately remember and tell. This kind of clarity I can only expect from you.
नहीं 5,000 टंका मु दउची आउ 1,000 टंका लेखे टुवर्ड्स एरियर दउची प्रति मास रे
Whatever आपण सुनंतु आपण 1/14/3/24 थ्रू जो 5,000 टंका दबा कथा that comes to आपणकर टोटल होची 1,20,000. आज पर्यंत हेले 1,30,000 हबो. So you have stated in your affidavit you have paid 40,000. He says 34,000. Even I have not entered into that dispute also. I have not accepted it version also. Apart from that, you have paid 20 lakhs or 10 lakhs or 5 lakhs, we are not discussing actually. Because what was the order and what the, now one thing you said, I have also noted that 6,000 DV he has not considered, but he has considered that 6,000 DV.
Then your lordship may pass.
Yes, it already passed. I have noted that.
Yes. Obliged.
That only 1,20,000, whether 1,20,000 is to be, how much has been paid, that is being discussed. Yes.
Obliged.
Yes, please.
Item 13.
Item 13, my lord.
Yes.
Compliance affidavit has already been filed.
Yes.
Your lordship.
Non-commissioned order dated 18/11/24, my lord.
Mr. Balabantarai.
Item
Mr. Behra. Mr. Behra, Mr. Balabantarai, who is appearing?
My lord, on behalf of SK Abani Ranjan Das, my lord.
Mr. Abani Ranjan Das on behalf of SK Bhanjadev for the petitioner. Mr. Dayalindhi Lekka, additional government advocate for the opposite party. So Mr. Abani Ranjan Das, can you hear me, please?
My lord, non-commissioned order dated 18/11/24, my lord.
So they have filed affidavit. Have you received copy?
Yes, my lord.
So now, if you are agreed by that order, you have to challenge that.
My lord.
Because keeping the content proceeding pending will not help you. And Mr. Lekka, for the delay, is there any delay in compliance?
There are some delays, my lord.
So have you stated the reasons and so you have not stated regarding the delay. You have not.
Yes.
So what to do now? Reject or you'll file better affidavit?
Anyhow, in 10th April, the order has been issued and passed and communicated to him.
How much time you have taken?
Your lordship may kindly see, the order was passed in 18/11/2024.
Is there any time limit fixed?
Yes.
What is the time limit?
6 weeks.
So, even I cannot extend that time unless there was a petition and a time was granted.
That's there, my lord. Your lordship may kindly condone the delay.
No, I cannot. Unless you seek for that. You have not sought for that. Neither you have tendered apology nor you have sought for condonation.
Only in paragraph 6 we have mentioned that the deponent has the highest regard to the directions of the Honorable Court.
He may not have regard, sir. Doesn't matter.
And but the deponent has complied with the...
Whether he is having regards or not, that is not the issue. The issue is that whether he can extend the time himself, or the court can and whether he can pass orders at his own will. He should have been conscious what he is writing.
Yes.
He must be a responsible officer.
Yes.
Please take care of this. In fact, you owe it to the system. You owe to the court. You are officer of the court. You have to take care of that.
Yes, sir. I bow down, my lord. For future, we will take care of it.
Okay. Appearance like the Lord AG refers to the affidavit single quote. Affidavit dated affidavit dated job. Last call it affidavit dated
14th May.
5/2026 and submits that it is with two quote single quote compliance affidavit filed by the opposite party against whom non-compliance of the order passed by the coordinate bench. This is by which bench? This bench. Compliance of the order dated 18/11/2024 passed in WPC number 27624 of 2024 is alleged. The Learned AG submits that though there has been some delay, the delay may be condoned taking a lenient view, and the deponent tenders unconditional apology for the delay in complying with the order dated 18/11/2024. Though the causes of delay or any apology is not sought for in the so-called affidavit, in the compliance affidavit, if persuaded by the Learned AGA, this court accepts the affidavit. The contempt application is dropped. Stop. The petitioner shall have the liberty to seek judicial remedy if so advised, as against the order dated 10/4/2026 passed by the director
Municipal.
passed by
Municipal administration. Director Municipal Administration.
Director Municipal Administration. In compliance of the order dated 18/11/2024 passed in WPC 27624 of 2024. Yes.
Much obliged.
Yes, next.
In next item, my lord, I pray, I have not yet received the instruction. I pray some more time.
Copy, sir, Mr. Leka.
No complaint has been filed, Your Lordship.
Yes, yes.
Copy, sir.
No, Your Lordship.
Complaints affidavit are not filed. I pray.
Hey, since this is a fresh matter, you have received copy, Mr. Leka?
Yes, sir.
Okay. Mr. Jagadish Vishwal, for the petitioner.
With Your Lordship, kind permission, can Your Lordship, last order? I'm sorry if I'm interrupting, Your Lordship.
No, I should be sorry. Only lawyers can interrupt.
The last order, 10th of April, Your Lordship.
Yes. Yes.
Yes.
You should have marked Mr. Leka's approach. So when he stated that, he said openly statement that I have not been able to. Yes. So that is how I was asking that whether earlier there was a direction or you have served copy.
My lord, I've served copy.
Jagadish Vishwal for the petitioner, Mr. D.L. Leka for the AGA for the opposite party. The Learned Counsel for the petitioner refers to the earlier order dated 10/4/2026. And submits that state the opposite party was to file compliance affidavit. The Learned AG in response submits that he has sought for instructions and will be granted further time to file compliance affidavit. Accordingly, the matter shall be listed for orders in the week commencing 13/7/2026.
Obliged.
Yes, next. Here the connected matter. Would have been. Should I disposed of key? Pending ଅଛି ବୋଲି ଦେଖୁଛି। So by लिखନ୍ତୁ WPC 27624 of 2024 केरल जोड़ा आछि। The writ petition is listed along with the CONTC 5585 of 2025. Paragraph 3 of the order dated 18/11/2024, the writ petition is directed to be disposed of. Stop. Accordingly, the office note should have indicated the writ petition to have been disposed of.
Yes.
Order कर दें तो last stage तो लिखा है नहीं बस पे लिखना है. Yes, next. 15. Hybrid mode लिखे हुए. The matter is taken up in VC, virtual court. None appears for the petitioner when the matter is called. The matter shall be listed for orders in the week commencing. Yes, ma'am. 20/7/2026. 16টা সে বলে প্রেয়ার করতে না কোন adjournment পাইব
মানে item 16 I am petition
yes please 16 yes is there Mr. Niranjan Singh
11 I have taken time but 11 I haven't taken time but 16 I am
okay yes Mr. Singh
well as per your lordship direction I have filed the detailed affidavit today my lord and counter I have already filed today my lord.
अच्छा केबे आसीबो ताले
लॉर्डशिप में कल टेक कर दे डे आफ्टर टुमारो
काली आसु तो काली कर दे ऑर्डर कर
आगे
से काउंटर रे फाइल करछन के मार्क पर लिखि नै छन आपण रजिस्टर मगे देबे ना मगे देबे रजिस्टर केबे आजी फाइल करले
मैं आज काउंटर रे फाइल कर सकाळे फाइल करछि
देखली तो आपण सिंपल पोस्टिंग करी कर देबे काली तर नहीं ठीक अछि काली आसीबो ताले
आगे
17 Mr. Das
May it please lordships.
Yes
Your lordships petitioner husband challenged the order passed on under section 144 of PNS lordships for maintenance in CP number 37 of 2025 passed by the family court Jaipur. Wherein lordships it has been awarded 5,000 for wife and 3,000 for minor son child, your lordships.
Yes.
Your lordships, unfortunately, this petition's case has not been taken care of by the local advocate at the family court.
That cannot be Mr. Das. That cannot be ground.
Neither he has filed any written statement, your lordships.
You should have. You should. I have been asking this to. In fact, I have been discussing this. I mean, he doesn't meet the lawyer. He doesn't talk to the lawyer. The lawyer will file a maintenance application. There is no such provision. So you must understand that. So there, at least for neglecting the wife, the daughter, and the lawyer, he is to deposit at least honor the decree 6,000.
Yes, lordships. Yes, I will take instruction, lordships. In fact, apart from that, lordships, he has filed a section 9 petition and that has been allowed. That is at annexure 3, your lordships, space 28, wherein he has not appeared, your lordships, and in fact, in this case, there is no conciliation has been made, your lordships.
Conciliation in maintenance cannot be made, sir. Conciliation because the state is not paying, the court is not paying. Maintenance conciliation cannot be made.
And the petition wants to take her back, your lordships.
You read that Supreme Court decision where Honorable Apex Court have held that even when there is a decree for restitution, the petitioner cannot be is not honoring that. So that is not the point to be argued. It has been discussed that whether non-compliance of Section 9 decree can lead to a situation where the wife will be deprived of maintenance.
In fact, before filing of the maintenance petition, this Section 9 petition has been filed, and that has been awarded later on after the award of the maintenance award.
Even if there is a Section 9 direction, it will not help for not paying the maintenance.
May I pray, Your Lordships?
And here that she cannot, because there is a threat to her life. Which court will enforce?
No,
if the person pleads that there is a threat to life, she was attempted to be killed by pouring kerosene and burning. Which court will take that risk? So, and this neglecting the lawyer, should the petitioner should at least honor the court, because the lawyer cannot file a maintenance application or Section 9 application.
That's right.
For restitution of client and lawyer relationship, there is no provision.
Yes, Lordship.
And it is so easy to blame the lawyer after you do not beat him during the case.
No, Your Lordship, that is not there. He has in fact failed to file a written statement. Neither he has declined the cross-examine the witness, Lordships, and there is no affidavit. Income liability affidavit has not been filed. Nothing has been taken care of.
So for that, lawyer cannot be blamed, sir. The party has to be non-filing of a written statement cannot be attributed to the lawyer, because a lawyer cannot prevent filing a written statement. You must understand.
Yes, Lordship.
So those things. So it comes to very simple thing. So what is the total amount due?
Total amount till it, Your Lordships, it will be 12 months, 8,000.
For what is
1 lakh
8,000?
8,000.
8,000 from 3-3-25. So it comes to
1 lakh
14 maso. 14 maso, 14 Osta 72. So 72,000.
Yes, Lordships.
So 14 Osta hochi lakhe 12,000. Lakhe 12,000. ଆଉ 12,000 ଟଙ୍କା ଦିଅନ୍ତୁ, ଆଉ ଓକିଲକୁ ତ ପଚାରିବେନି, ସେଟା କିଛି କରିହବନି। At least ତାଙ୍କର ସ୍ତ୍ରୀ ଆଉ ପିଲାକୁ ପଚାରନ୍ତୁ।
I will take instruction, Lordships. If Lordships, please to notice or
notice,
Mr.
Das, notice does not ensure compliance. Order 41, rule 10 says.
That's right. That's right.
Rule 10 and 11, if you read, now it has been amended that the court can dismiss without calling for the records.
Yes, Lordships.
And there is one government also, Sri Lalita, that parties cannot be asked to join litigation.
Yes,
you see, by litigating all through, Section 9, she could not get anything. 125, she could not get anything. Now the High Court will add to that and invite her that you come here and approach.
No,
and the petitioner does not even look at the lawyer. So
I will take instruction.
Yes.
Amount, let it come after vacation, Lordships.
Yes, Mr. Arun Kumar Das for the petitioner. Opposite party black. The petitioner before this court is the husband in the marriage. By filing the application, he seeks a revision of the judgment dated 13-1-2026, passed by the learned judge, Family Court, Jajpur, in CR.P. number 37 of 2025. Stop. The said CR.P was filed by the wife in the marriage and the minor child. Is it about 4 years? Represented through his mother guardian under Section 144 of the BNSS 2023, seeking monthly maintenance at the rate of 20,000 for the wife and 5,000 for the 5,000 for the minor child. The application was favored. However, granting monthly maintenance, rupees 5,000 per month for the wife and 3,000 for the child. Challenging the said order, challenge the judgment, it is submitted by the learned counsel for the petitioner that the petitioner has not taken steps defending the case before the learned trial court. In considered opinion of this court, whether the petitioner has taken the steps through the counsel or not cannot be a ground for seeking revision. So it is further submitted that by judgment dated 27.1.2026 passed in CP number 15 of 2025, the application filed by the husband petitioner under Section 9 of the Hindu Marriage Act seeking restitution of conjugal rights has been allowed ex parte against the wife. In so-and-so versus so-and-so, the Honorable Apex Court have held Rupali Devi. So, the Honorable Apex Court have held that direction for restitution of conjugal rights and in case of direction for restitution of conjugal rights, when the wife has not complied, the same cannot be a ground to refuse her maintenance under Section 125 of CRPC. Perusal of the application filed under Section 144 BNSS shows that the wife and minor child have been neglected. The wife was apprehending for her life, as stated. The allotted counsel for the petitioner is apprised of the decision rendered by the Honorable Supreme Court in Samima Faruqi versus Sahid Khan. Citation level, comma, elaborately dealing with the scope of interference of this court in revision of judgment passed by the family court in exercising jurisdiction under Section 125 CRPC. Guaranteeing payment of maintenance, paragraph 19 and 20. Then so far, the allotted counsel is also apprised of the judgment of the Honorable Apex Court in Rajneesh versus Neha, wherein it has been held that the amount of money awarded as monthly maintenance to wife and child is akin to money decree. So, the petitioner shall file affidavit indicating how he will secure the amount due, which comes to about rupees 1,20,000, 1,12,000, up to March 2026. April 3rd May 12 plus 8 20 28 1,28,000 from due from 3/3/2025. at rupees 8,000 per month. The matter shall be listed for fresh admission in the week commencing 20 7. Rest of the matters, anyone mentioning any matter for adjournment?
No. So that's item number 20, Your Lordship will
Item
recollect.
number 48, Your Lordship. Last two chance it was adjourned.
48, sir, we have to reach there, sir. What you want, sir? You want to be taken up? Sir Ponda.
My Lord,
Item
but
21.
petitioner is absent, Your Lordship. You're not cooperating with him.
Let us see. I understand. But for that you have to.
After lunch, man. I will.
Mr. Item 20, what do you want?
That's 20 is a fresh matter. Your Lordship had heard extensively on the last date. This was posted today.
So you want it to be taken up? I'll be continuing after recess. We can start around 2:15.
No, but what I was humbly requesting is if this can be taken up some other day, because I
after
have to take
vacation.
Yes, please. Yes, please.
20.
Pardon to mention, my lord.
Just one second.
My lord.
We are going one by one. Item 20.
We can say Amprish.
29.6, he is saying, Footmaster is saying.
Yes, my lord. I'm obliged.
3-6-24.
Pardon, my Lord. My humble submission with Your Lordship. I beg apology for that. But this matter may be taken up on 21st or 22nd, Your Lordship, because the transport petition. Unnecessarily case was.
Which one, sir?
48 item.
48, you are the opposite party or the petitioner?
I am the opposite party, Your Lordship.
So you have to wait, sir. You want adjournment or let him pray or you want after vacation?
My humble submission, let the matter may be adjourned to 21st or 22nd.
Of June, July, August, September, which month?
This month, my Lord. This calendar month.
No. It is listed, it will be taken up with riches. Why it will be adjourned? If you want, because you are for the opposite party.
My Lord.
Item 24, my lord.
Okay, I will wait.
24, my lord.
No, you need not wait. If they are not appearing, why should you wait? Let us see.
Yes.
24, Mr. Mahanti?
Yes, my lord. After vacation, I will file counter. I have intimated to the senior board of.
Mr. N.K. Misra, you have intimated?
Yes, I have intimated.
So I have to see that. I have to pass that order. If you are not there after recess.
Yes, ma'am. I will. Yes.
Okay. Sir.
Pardon to mention, my lord.
Yes.
Item 21, my lord.
Yes, 21.
Can be taken up after vacation, my lord.
Your name, sir?
Samir Kumar Singh, my lord.
SK Singh. Okay.
My lord.
Date karo to 21.
We can say 6-7.
6-7 20-26.
My lord. Obliged, my lord.
Yes, Mr. Prabhu.
My lord. No, I was just noting down.
Yes. We'll continue after recess.
My lord.
2:15 we'll start resume. Because already it is good.
May be pardon to make a mention.
Yes.
Item 40.
Yes,
I have intimated to my learned senior, Mr. Bhuya.
So let him come. If Mr. Mahapatra or Mr. Bhuya comes, then no difficulty.
His request is for taking up the matter to tomorrow, madam.
Set up post kar diyo.
Tomorrow, fresh.
केते नंबर आइटम आउथरे कहले
40 my lord 40
40 टा काली कर दो
tomorrow fresh my lord
फ्रेश हे परियो फ्रेश करियो
ए ऑर्डर से हिजबो मु आईए टा फाइल करछि लॉर्डशिप कैन कंसीडर आईए इज देयर
काली ऑर्डर्स कर दियो
ओब्लाइज गुड
सिंपली अर्जन करियो बुझले ऑर्डर हेले फाइल लिस्ट हे परियो नियो if order is passed it has to be returned order type signed returned
lordship simply urgent
simply the court master will post it
man oblige
yes please
item 30 का 3टा
30 टा ओ देखिए
item 18
item मैं pardon to mention item 20
पासओवर किसी डेवलपमेंट अच्छा पासओवर नहीं ठीक है
item 18 my lord
Pardon, my lord.
sorry what mention कौन करछोती yes
मैं item 25 my lord
25
में on behalf of Mr. Pujari my lord मैं kindly after taken up after vacation
just talk to Mr. Misra or any of his accounts any of his lauded associates say optile Mr. Misra was present
I will inform my lord sir
just give some time because it will reach because by this we are not doing anything so you can wait so that it will reach immediately yes
item 18
my lord item 18 my lord
Pardon, my lord. Item 15, my lord.
My lord, your lordship called out item 25.
25 was mentioned by Mr. on behalf of Mr. Pujari. Mr. Nayak mentioned.
Your lordship is adjourning it.
No. I am not adjourning. It is a mention by Mr. Nayak kuhuntu. Se bhavuchandi mu call korchu boli.
Mr. Pujari has some difficulties that's why I kindly take after vacation.
So I suggested him that you please wait. Mr. Misra is there in online. So he was waiting for you. In fact, he was waiting for you.
As your lordship pleases, it may be kept to reopening or something like that, subject to your lordship's convenience.
ताले 25 टा को खाली सिंपली कर देबे डेट करंतु केबे डेट है
commencing 29/6
we commencing 29/6 Mr. Nayak
my lord
Mr. Misra 29/6 he also agrees he is present
my
in
lord
court
order ta extend ho my lord interim order
अच्छा ठीक है interim order to call कला बेले मतलब डाकी आउत देखो I will pass the order when the matter is called
so may I take your lordship's leave my lord
yes
my lord.
Since he mentioned, I said that you wait for Mr. Misra. He was present, so
my associate will be there. I am only taking your lordship.
No difficulty. When both of you can, Mr. Nayak, your name is there.
इसके बेहरा
I'm sorry.
My power is not there मेरे.
अच्छा, I'm sorry. आपन को hair color पूरा change हो गया आपन जोड़ा पड़ना तो सुबह.
But he happens to be my friend.
Yes.
I am coloring, therefore it is black. He is not coloring, therefore it is white.
So not much older than me also. So Bera, yes, on 29 Yes, I'll pass that order. Both of you can have leave. Yes.
Obliged.
Pardon, my lord.
My interim order खाली extend हो my lord.
Yes, okay. Interim order to call. Yes, the court master has noted. He is not visible because we don't have extra camera.
My lord.
He's sitting besides. अपन ऐसे देखा करो समझो.
नहीं.
Yes.
Yes. Pardon.
Non-apparent ହେଇଛି 18 ନାଇଁ 15 से mention କରୁଛନ୍ତି
Yes, my lord. If I may allow to present, my lord.
non-apparent वो commission 27 for orders
27 पर order says
Yes, my lord. But
भले non-apparent you are Mr. Panda Sunil Kumar Panda
I am Dakshesh Darshan Naik, DD Naik.
अच्छा DD Naik
Yes, ma'am.
15 रे जे नेचंती कहबे DD Naik note करतो
My lord, we had filed that affidavit, my lord.
Okay.
On the last occasion, that.
अच्छा, you want to matter to be taken up?
Yes, my lord. If.
अच्छा, ठीक है 15 टा अंदर कॉल करो.
item 15
Oblige, my lord. My lord, as per instructions, my lord, we had filed that affidavit, consolidated affidavit,
in the in form of a memo on 10/4/2026, my lord. In the last occasion, it hadn't come up in the paperless form. It had come up now, and my lord, as per the direction of this honorable court, in the para 6, we have consolidated all the arrears, my lord. And as per now, since 22/7/2022 to 1/1/2026, arrear monthly maintenance is 4,40,000. Interim maintenance paid by appellant is 1,12,000, my lord. And today, my lord.
Sir, your problem is that again, upon a date kichi lekhu na. You are always struggling with the dates. ଆପଣ 5 ପାରା 6 ପାରା ଲେଖୁଛନ୍ତି, ଆପଣ କୋଉ ଦିନ ଦେଲେ କୋଉଥିରେ ଦେଲେ ସେଟା ଲେଖୁନାହାନ୍ତି. Read paragraph 4.
Yes, ma'am. Pursuant to the said orders, arrear maintenance from 22/7/2022 to 30/11/2025 was assessed to be 4,20,000, out of which the petitioner has already paid 1 lakh.
So you have been told that don't use this words already paid. Paid ette on ette.
Yes.
And you are struggling with that.
My lord, if I may, my lord, you
Sir,
had
what I can do, sir? What already I can impute a date on that.
But my lord, based on this,
you are just writing essays and wasting time.
My lord, based on this,
if you can write a sentence already paid so and so, you can write the sentence paid 1,12,000 on ette. That's it.
My lord, also today I have filed that through a memo again, the monthly payment of May, my lord, maintenance, which also
you are struggling with the date, sir.
Yes, ma'am.
The order is very clear. I don't know if I'm as confused as the petitioner when I'm passing the order.
Apologies for the ignorance, my lord.
My
instruction, my lord, we are as
Nayak, ignorance is bliss, but absolute ignorance is disaster.
No.
Read 18.3 order.
Okay.
Read it loudly. You were already in a remote location, so read it loudly. 18.3 order.
Yes, ma'am. The petitioner shall file affidavit in one page indicating the date of payment, proof of payment, and amount payment and the amount.
That should be the amount. So instead of saying that already paid, due so much. What is this? The matter was passed over and again called. Had learned counsel for the petitioner. The learned counsel for the petitioner refers to the affidavit dated
10/4/2026.
10/4/2026. Along with memo dated 10/4/2026, which he states that is in compliance of the order dated 18/3/2026. Perusal of the affidavit indicates that it runs into pages. So the specific direction, though it was directed by order dated 18/3/2026, quote karantu, the petitioner shall file affidavit in one page indicating the date of payment, proof of payment, and the amount paid. Somehow, for the last 2 months, the petitioner is struggling with the same to disclose, though memos and affidavits are being filed. For example, at paragraph 6 of the affidavit, paragraph 4 of the affidavit, the following has been stated. Paragraph 4 and 6. Both the paragraphs, as indicated above, does not indicate the date of payment, the amount paid, and the mode of payment. The petitioner has further opportunity to file the affidavit as directed by order dated 18/2024, and also shall not use this opportunity to file affidavits without being specific, and also directed not to use the opportunity to file affidavits which are not specific. Yes, Mr. Naik, read from para 4 and 6. You get the date and payment?
Yes, my lord. No, my
Kindly
lord.
place it. Which date you have paid? How much?
Apologies, my lord, but no.
Yes. Matter shall be listed. So, କେବେ କରିଛନ୍ତି? ସେ 27 କରିଛନ୍ତି, ଆପଣ କେବେ ଚାହୁଁଛନ୍ତି? 27?
Yes, my lord, no problem.
The matter shall be listed for orders in the week commencing 27, 24. Yes, please.
Item 18.
May I please, your lordship. My lord, today, my lords, I filed the affidavit, my lords. As per the my lords.
କାଲି ଆସିଲେ ହବ?
Yes, my lord.
ପୋଷ୍ଟିଂ କରିଦେବୁ। ଦେଖିବେ affidavit filed to be brought. ଆପଣ କେମିତି ସେଟା କହିବେ ସେଠି? ସେଟା ଡିସଲୋକେସନ ଟିକେ ହବ ନା, ସେଠି ସେ ଫାଇଲ କଲେ ଆପଣ ଏଠି ରହିଲେ ପ୍ରୋସିଡିଂ କରିବେ। ସୋ ଲେଟ୍ ଅସ୍ ହୋପ୍ କି କାଲି ଆମେ କରିପାରିବୁ, କାରଣ ଆମେ ଯେହେତୁ ରିମୋଟ ଆଉ ଲୋକେସନରେ ରହିଲୁ, ସେଟା ସେଠି ତ ଆଉ ଆସିପାରିଲାନି ବା ଆସିପାରିବନି, ପସିବୁଲ ନୁହଁ। କାଲି ଦେଖିବା ଆଉ। କାଲି ହବ ତ?
Yes, my lord.
ନା ଆପଣଙ୍କର ବି ମିଷ୍ଟର ନାୟକ ପାଞ୍ଚ ଥର ଆଫିଡେଭିଟ୍ ଫାଇଲ ହଉଛି, କିନ୍ତୁ ଠିକ ଅଛି। ନେକ୍ସଟ
Item 19.
লিখিবে এটা 29 তারিখ পরে লাস্ট টাস্ক করতে পারে তো 18 মে আছে petitioner now. The matter is listed for orders. None appears for the petitioner when the matter is called. Agar likhiwe hybrid mode, tapare the matter is taken up in virtual mode. Tapare eta likhiwe. Okay? Matter is open up virtual mode. हाँ, देखो. तो change कीजिए ना जाने में. Hybrid तो थिला, but code virtual mode. माने code was available. On 29/4/2026, the following order was passed. Today, when the matter is called, today the matter is listed for orders, and listed for fresh admission. None appears when the matter is called. This is item 19. 19. Okay. Grant further opportunity to the petitioner Matters shall be listed in the week commencing 6/7/2024. Listed for fresh admission.
Item 22.
Dated 7/5/2026.
So Gyanendra Chandra Swai for the petitioner. Hybrid mode. The matter is taken up in VC. Opposite party black. Yes, Mr. Swai.
My lord, according to order of this honorable court, my lord, order 7/5/2026, my lord, the petitioner has filed affidavit, my lord, on 15/5/2026. That he will.
You want after vacation or today?
My lord, she will adduce evidence, my lord, on 20th July 2026, my lord. Without any adjournment, she will adduce her evidence, my lord. And she has filed the affidavit on 15/5/2026 before this honorable court, my lord.
15/5 Asinokyu. Mr. Swai.
My lord.
Since I am at a remote location, so that file is not there. So tomorrow, court master will take note of that. It is simply it will be listed tomorrow.
My lord, tomorrow. Registry directed to.
But problem is registry is not available here. I am not available with the registry. Same thing with the court master. Court master is not there. He is available here. So, देखिए जो 22 रे tomorrow कर दियो तो affidavit filed on 15/5. Yes, 15/5 कहले ना?
15/5 my lord.
Yes, 15/5 रे affidavit file लीजिए पूछो. चलो.
Public.
Kal asu. Yes.
What is this?
Yes, 23, Mr. Das.
Item 23.
Yes, madam.
Sir. So,
Sweet fellow.
Vaida Senior Counsel along with Mr. N.C. Mahanti for the petitioner. Yes.
My lord, we challenge 3 orders, my lord. One is at page 28. My lord, the background of the list is that we had come in a writ application earlier. A mandamus was issued that you hear the matter and recast the issues, my lord. Having gone back, my lord, the mandatory provision of 10(2) and 14 have been absolutely not followed. Then, my lord, may I kindly see page 28.
28, yes.
My lord, may I read, my lord, the last 3 lines of the top paragraph? Those, my lord, I'll just read from first. Though the parties were examined by the court as per 10(1) and 2, subsequently the substance of the examination as per 10(3) and 10(4) have been noted by this court as well as being the family court, the direction of the parties to offer any mode of alternate dispute and conciliation, so and so, so and so. Inadvertently, the examination of the parties has not been categorically mentioned in the order sheet dated 13/10/2025. Till now, my lord, it's not seen the light of the day when the respondent filed the WS. Hence, in the interest of justice, the respondent is consistently praying for noting of such fact in their order sheet as well as the same being a mandate of law put upon so-and-so. So far as the petition of dated so-and-so is concerned, the same will be automatically followed after examination of affairs.
Till 10/25 is a typographical mistake.
Yes. No, my lord, it is not there in the order sheet at all. We have filed an application for a certified copy. That's not there in the order sheet at all. That's my grievance.
No, my point is a little bit different, little bit nuanced. What the court means by 1310 order, it could be a different order which is wrongly typed. That I meant to say. Because court by saying categorically mentioned in the order sheet, so obviously it has referred to a order but wrongly typed the order number. You are right, there is no such order.
That order is not there, my lord. We filed an application.
So that is some other order which the court meant to type, because the sentence is like this. When the respondent inadvertently, the examination of the parties has not been categorically mentioned.
Yes, madam.
So you have to see the order sheet on which date it has been mentioned.
That is this order sheet that is conspicuous by its absence, my lord. We asked for a certified copy. It's not there at all. That's my grievance. And my lord, may kindly see the next order.
So before the Lord Judge Family Court, Bhubaneswar, you are the opposite party.
Yes, my lord. It arises out of a divorce proceeding, my lord.
Did you file any application for clarification of that date?
Yes,
the
my lord.
problem is, we cannot second guess. I mean, both of us. You as a counsel or me as a, appellate or supervisory court. We cannot second guess the date. What is the response of the court to that? Have you filed any application?
Yes, my lord. We filed an application. That has been rejected.
Where? Kindly show that application. Kindly show that application.
Yes, my lord. Application I'll show, my lord.
Page 91.
Page 91, my lord.
91.
Annexure 15. An application under Order 14, Rule 1 CPC, framing of issues, and Order 3, Order 3 of the Order 10, Rule 3 of CPC for substance of examination of forming of the part of the record.
This application is dated?
This application is dated, my lord.
9/12/25.
So 9/12/25, yes, I also see that 9/12/25.
Yes.
And the order you are reading is dated?
The order that I am reading earlier, order of the court.
Correct. Yes.
Yes. That order is dated 4/5.
4/5?
4/5/2026.
So that I wanted. My point
and the
is,
other one, the next one.
So that 4/5/2026 order.
Yes, my lord.
After that, have you filed any application simply saying that date is missing? So please clarify. So that I wanted actually. So I got your point that pursuant to your application, the order has been passed or rejected.
Yes, my lord.
226. Page 140.
140, my lord.
140 to 177. Petitions were filed.
140 to 177.
No, that petition is 5/2/26.
Yes.
The order is of the month of April. Kindly take that page again. 25 order, there is apparent, there is something missing in that 13/10 date.
Yes.
So now I cannot suppose you are agreed by this 25 order?
And the subsequent order.
The subsequent order, my lord. The
order is?
Yes.
Annexure 2.
Annexure 2, my lord. 1, 2. Yes, sir. I'll just take my lord through that order.
4/5/26.
Annexure.
Page 29.
Page 29, Annexure 2. Both the parties are present along with their respective amicus curiae. The respondent filed an application 151 for clarification of order dated 25/4/2000 and modification thereof. The ground of error apparent regarding recording of 10 CPC compliance. The amicus praised that the petitioner orally objected to peruse the order. In spite of repeated settlement of issue, the respondent categorically pleaded for compliance of 10. Therefore, both the parties are again called upon for compliance of 10. Hence, considering the present circumstances, petition is being devoid of merit is rejected. Both the parties are examined as per so and so. And no examination, my lord, thereafter. And then the next order.
Next page.
Next page is the next order, my lord. Where, yes, my lord. Next page, Annexure 3. Both the parties appeared in person, both are examined.
No examination has been.
No examination has been, no record of it.
So you want a stay of the proceeding?
Yes, my lord, because what is happening, my lord, is proceeding. My lord, the difficulty is this, that the grievance is very serious of the petitioner, my lord. He is a very well-educated person, my lord. The marriage was solemnized with a person, my lord, who had a self-harm disease, my lord, which was not given, disclosed at the time of marriage. Well, what she did in the first month, 3 months itself, she cut herself. She'll put hot water on her body. Things like this continuously happened, my lord. And then she came and then she filed a case here. And then we had gone on a holiday before that, after that. In the process, my lord, harassment
But
was
Mr.
so
Das,
high.
you are agreed by which part of the order? Actually, I could not get.
The part of the order where he has, they have not been examined, my lord. Order 10, the mandatory provision of Order 10, Rule 1 and 2, 1, 2
Saying
and
though
3.
it is recorded that they have been examined, they have not been examined.
That is the point. That is the point.
At page 3. I'm
Yes,
sorry,
ma'am.
Annex 3.
Answer 3, yes. He writes in the previous date, examined. No examination, then passes the same order which was passed by him earlier.
The learned, it is submitted by the learned senior advocate, senior counsel, referring to the order, recording to the order dated Chari. Is that what is the date? Chari 5/2026.
Yes, yes, yes.
Chari 5/2026. Chari 5/2026 passed by the learned judge, Family Court, Bhubaneswar, in CP number 90 of 2025.
Yes, ma'am.
Which indicates thus. The quote कर देगा annex होता है reproduce का scan भी यही करिए. Indicates thus. It is submitted that though the learned court has recorded, both are examined within court. Both are examined, but in fact the court has not recorded any statement under Order 10 Rule -3 CPC. No such recording of statement is available on records of the learned court. He submits that if the matter proceeds further, issue frame है गलत आप है.
Yes, yes, my lord.
The matter proceeds further without examination of the parties. That would prejudice both the parties and more so the present petitioner, husband in the marriage. कितना हो रहा है? 23. Yes, husband in the marriage. Stop. So notice along with this order to the opposite party, requisites for issuance of notice by speed post with registration and proof of delivery shall be filed within 3 working days. Stop. Returnable date be fixed to
whichever date.
The matter shall be listed on 6/7. A returnable date be fixed to 6/7/2026. The matter shall be listed for orders in the week commencing 13/7/2026. आइए 9064 of 2026. Next date के भी जान सकते
June 18. June 18 or something.
अच्छा हमारा गला जुलाई को गला ठीक है. Hard noted senior advocate for the petitioner, he reiterates his submissions as noted above. Issue notice as above, accept one set of process fee as well as postal requisites. So, it is submitted that the next date of listing of the matter before the learned judge, Family Court, Bhubaneswar, CP कर दें तो CP number 90 of 2025 for learned judge, Family Court dash Roman 1 with capital 1 Bhubaneswar is 18 June कहले.
My lord, I will confirm again.
अच्छा is
I supply it to the court.
अच्छा ठीक है. Is एमपी कर दियो सेंटेंस कोड तो लिखिए मैं काट दो. In the interim, it is directed that on the next date of listing, the listing before the Learned Judge, Family Court Bhubaneswar, Family Court 1 Bhubaneswar. The matter shall be adjourned beyond a date. 13 kale. Beyond a date 20/7/2026, as would be convenient to the Learned Court in season of the matter upon a prayer being made for the state purpose.
Deeply obliged.
लिखी देंगे अब जो the returnable date and the next date of listing shall be as directed above. Yes.
Deeply obliged.
Yes. Mr. Jaswanta Das, Mr. Y Das, here comes it. With Mr. N.C. Mahanti, Nirmal Chandra Mahanti of the petition.
Item 24.
24,
Please,
Mr.
Your
Mr. Mahanti was seeking adjournment.
I'm here.
I guess he is 85 years of age and
I
a
will file
retired
objection
teacher
to the
is only
petition.
suffering.
Lordship.
अब कितना टाइम नेबे तेरे He has been getting some pension, but is entitled to the extra 20% and 30% of the pension after reaching the age of 80 years and 85 years respectively. That has been denied.
They have sought the copy of IA. I will file objection.
January service copy upon
Mr. Mahanti, so enhancement at the age of 80 is an automatic thing. That is authority
automatic.
I think it is not.
Let it
There's
be,
no discretion.
my lord, after vacation.
No. There is a purpose, Mr. Mahanti, I mean, discussing with you or speaking to you, that when something is not discretionary, then how you have to impress upon your client that if somebody is getting pension and this 80 years is by the pension rules.
Yes, my lord. Put up.
Anyone. So, senior citizen, super senior citizen, all these things, they are even in fact for the state government where it is being operated by banks like State Bank of India, they are doing it on their own.
Yes.
Let it be tomorrow, my lord. Let it be tomorrow.
Hey, आपण tomorrow करके adjournment करंतु.
Full time नहीं गला
आपण positively आपण चाहिले हबो माने you have to use your good offices. Hello?
Yes, sir, tomorrow.
छुट्टी परे आसु, but you please do it.
Right, sir. Right. More
Mr. N.K. Mishra, senior advocate, along with Nitish Kumar Mishra for the petitioner, Mr. S.S. Rao, senior advocate, along with Mr. B.K. Mohanty for the opposite party. It is submitted by the Learned Senior Counsel for the petitioner that there has been no enhancement of pension amount received by the petitioner after crossing the age of 80 years and 85 years as is provided in the pension rules. Stop.
Pension rules. Sir, pension rules notification which I have given.
As provided in the pension payment scheme as per notification.
Annexer 4.
To bracket Annexer 4 or comma bracket Annexer 4.
Annexer 4.
He refers to the IA filed by the petitioner. A copy of the IA has been served on Mr. Mohanty, Learned Instructing Counsel for the opposite party. Mr. Mohanty submits that he may be granted further time to obtain instructions. Mr. Mohanty is also apprised of the fact that if the rule provides for enhancement of pension upon attaining a particular age, there would be no discretion on part of the authority whether to grant or not to grant if the person is already receiving pension.
Yes.
Stop. The matter shall be listed for orders in the week commencing 29/6/2026.
Sir. Great.
Yes,
25.
Mr. Samir Kumar Mishra, senior advocate, along with Mr. Raut, S.K. Raut.
And Lord Rakesh Raut.
Mr. Rakesh Raut for the petitioner, Mr. S.K. Behra on behalf of Basudev Pujari for the opposite party. Adjournment is sought for on behalf of the Learned Counsel for the opposite party due to personal difficulty. Stop. Accordingly, the matter shall be listed for orders in the week commencing on 29/6/2026. Stop. Pasapar. interim order dated at shall continue till the next date of hearing. Yes.
Item 26.
May I please,
Yes,
may I
please.
please, Your Lordship?
Mr. Narayan Prasad Parija for the petitioner. Yes, Mr. Parija.
In this case, the only point in this case is that whether a maintenance can under 125 is maintainable after a regular divorce. Divorce was made under Annexure 1, awarding 5,20,000. And after that, it was judgment.
Notice, I think, sir, notices were issued, but I think it is not. We have to await sufficiency of notice.
But I pray that the order under Annexure 4 be stayed. Because,
Execution hichi ki?
my lord,
Execution.
my lord,
Have they launched execution?
my lord, in that case, my salary has been attached and 7,000 each month is deducted. But I have paid the 5,20,000 on 31 service. So I pray that Annexure 4 is to be stayed. And in meantime, he has also taken 70,000 more by attaching my salary.
You have deposited series child.
31 service. I have deposited and he has taken also.
Se seta kouthre memory fail kale?
No, by bankrupt.
Na apana ei court re kouthre fail kale?
No, in the court at Kamakhya Nagar.
Tar order sheet achi ki?
My lord.
Order sheet ta kali asu ka apana kali order sheet ta dekhei diontu. I have to record that. Kindly look at order dated 28/1/2026. Office take order ta achi?
Aya.
Dekhuntu para 4.
Para 4. I am reading that order.
Yes, please. Para 4.
31/3/26. The part record is opened today on the strength of advance petition filed by the petitioner through advocate. The said
नहीं सर सेटा मो पर नहीं सेटा टिके आपण दबक पड़ियो एक्चुअली प्रॉब्लम कोन हला कि बर्तन तो आपण पाखरे थिले भी आपण अफेयर कर पर नांती मु भी रिमोट लोकेशन रे रहली एटा काली के आसु
काली इन कोर्ट
आगे काली आसु सिंपली अर्जन ले जाओ आप माने अर्जन होबनी पोस्टिंग हे जो कने ऑर्डर कर देले फेरे आउ थरे फाइल फेरेबा को पड़ियो
हां काली पोस्टिंग हे जाओ
कने एबे चाहिले भी देखि परिबेनी सेटा सो यू हैव टू बी आपण काली आनु तो
मैं only pair let it come on top list. ये के तो 5 भीतर आसु
नहीं सर ऑर्डर्स रे आसु यू लिबर्टी टू मेंशन आसु ऑर्डर्स रे
आया
आपण ऑर्डर्स फ्रेश एडमिशन के जान पे ऑर्डर्स रे हे जो काली जानो तो
आया
आपण जो ऑर्डर ता सर रिलाय करछंती से डिपॉजिट करले से कॉपी करके मेमो करके काली दे देबे
हां दे दी
so that it will be on record.
I have got Xerox copy of the order.
Yes, whatever you file it with a memo with the court. Keep it ready. Keep it ready.
My lord.
Yes. Yes, next please.
28.
May I please
28, Mr. Tripathi, you are there?
I'm sorry, madam. I'm 29. I'm sorry.
28. Yes, Mrs. Mahanti, item 28.
आज ये अपियर करियो बोले कौन थिले का अपियर कर लेनी अपोजिट पार्टी
काली के आनिबा
आफ्टर वैकेशन अस
Oh. Mrs. Kaveri Mahanti for the petitioner, item 28. The learned counsel for the petitioner refers to the earlier order dated 14/5/2026 wherein her submissions were noted that the learned counsel on behalf of the opposite party appearing before the learned judge family court Bargarh in MAT case number 16 of 2025 shall remain present in VC. Today, though the matter is taken up in VC, no one is present on behalf of the opposite party. Stop. It is accordingly submitted by the learned counsel that the matter may be adjourned after vacation. Stop. The matter shall be listed for orders in the week commencing 27, 24, Mr. Mahanti.
Yeah,
I'm sorry, Mrs. Mahanti.
interim order continue wala.
Interim order.
299.
Interim order dated
299. 299/25.
नहीं तारीखटा 15 ना 25 तारीखटा कहले interim order dated 15 ना 25 shall continue till the next date of hearing.
Published.
Yes.
29.
Yes, Mr. Das and Mr. Tripathi.
Lordship, in the first letter, I am for the opposite party, my lord.
Yes.
In the second one, I am for the petition.
Lordship,
Yes.
only the last order. Last order, Lordship, may kindly say.
Last order in 18497.
My lord, in both the cases, Lordship has indicated. And my submission is also noted, my lord, there.
Order dated 4/5/2026, my lord.
Yes, Mr. Tripathi.
Lordship, my lord.
Any instruction?
Yes, my lord. The instruction what I have received, my lord. Admittedly, my lord, till date I have not deposited any maintenance.
Yes.
But the fact remains, my lord, here I am challenging that application on the ground that, my lord, the opposite party wife, my lord, that she is at present engaged in two different organizations, and in one organization, my lord, she is getting...
Mr. Tripathi, you are. I hope you are not following the way the revisions are argued in Odisha before me. Are you referring to the pleading or making just you refer? It was your stand before the learned
My
trial.
only submission is that, my lord, with regard
Not
to that...
only submission, sir. That can be the possible submission also. Can you listen to the question? This was your stand before the trial court. Then show that. Then what is the evidence and what is the finding? So that not a debate competition.
WBC number 16,945, the next one, my lord. That is the ground of my
Whatever,
challenge.
whichever WPC in this matter. So this arises out of one application.
Yes, ma'am.
So
She
in
has
that
filed for
application, what you are giving, that the wife is engaged at two places. So what was your stand there? So from that, not a speech here.
Lordship,
Because if I'll do that, then the Supreme Court comments on me that lack of application of mine. I cannot hear it again.
Here my only submission is that, my lord.
Only submission you do. Only submission apanakar thrice obani. This is not a medicine. You go to the pleading. Refer to your pleading before the family court. That where you have stated this and what is your evidence and what the finding of the trial court.
Lordship, may kindly say page number 51. The exact finding is there regarding this.
Mr. Tripathi, Korantu, she is satisfied.
My lord.
My only submission is that, my lord, that
only submission I cannot record because I like you so much.
I only pay to file an affidavit, my lord, before lordship.
No.
That she is getting 80,000 rupees per month from one.
Cannot be allowed. If you are making that prayer, I reject this prayer and application also.
And on
there
that
is no scope of filing. This is not a read 226. This is revision.
On that ground, no, this is the
227, sir. This is not 226. 226, we are filing counter, rejoinder. You have to go to the pleadings before the trial court. Which you are not doing.
The second item which I filed, that is a writ application, my lord. On the writ I filed.
First is also a writ petition, but not 226, 227.
Lordship, madam. But
counter rejoinder इतने अपनी अपन pleading को जान तो pleading अपन पहुंचे नहीं first of all doubt है.
I have some. In fact, I have not gone through properly.
मतलब कहीं बिल कोर्ट ले ना पड़ी. ଆପଣ ଯୋଉଟା argue କରୁଛନ୍ତି that should be there before the trial court. I cannot have a retrial of the thing. 227.
That grounds are taken. That grounds are taken before the learned trial court also. That is already taken into consideration.
80 grounds
And
80 grounds
with regard to that also, my lord, a complaint case has also been filed against the wife
written
before the
statement
learned
written statement buझुचंती objection written statement
Not sir, I would have date also given date.
Is this going on, sir?
My lord, my only submission is, only objection is, my lord, let them comply with the order at least 50%. Nothing they have paid. So this is the situation, and wife has not filed any other application for maintenance. So this is the only maintenance application she has filed, and the due is now, my lord, near about 2,80,000. And see, they have not paid anything, as my senior has agreed.
If you also
that they have
calculate
not.
the area is as on date 1,56,000. But my challenge is that
by challenging you are not granting stay. You are not Supreme Court. Even I am not granting stay, you have become Supreme Court. You will stay because you have challenged. You read order dated 4/5. order ଅଛି ନା ନାହିଁ Mr. Tripathi? ନା ସେଟା ବି ନାହିଁ. ପଢନ୍ତୁ.
Learned Counsel for the petitioner submitted that despite the direction of the Learned Judge Family Court, Bhubaneswar, no amount has yet been paid. Para 2, Learned Counsel for the opposite party shall obtain instruction to deposit the amount of arrear before the Learned Family Court till date by the next date. My humble submission, I have not paid, did not deposited anything before the Learned Court.
So let it be dismissed. If you are bargaining the decree, I am not going to entertain that. I am not entertain.
My ground of challenge is that will not cease.
Yes, your ground of challenge is very good, but after you pay, that ground will be considered. Very good ground. But of course, looking at your pleadings, you should not have reproduced what your client told you. You should have gone through the pleading. You should have examined it. What are the evidence? Then you should have started arguing. What is the difference between your client and you? Whatever he tells you, you are repeating in the court. And every time you are saying, my ground of challenge, I have told you, show the pleadings. Then you are struggling. And that then becomes a struggle for me also. Because I cannot
I'm sorry that I have not gone through the pleading.
Sir,
but this is the ground that I have not gone through. If some difficulty that I could not go, I would have dead
tomorrow. Either you deposit or get it dismissed.
I have some difficulty, my lord. Any day after.
Have you filed an execution, Mr. Das? That is state.
That is pending, my lord.
So you proceed with the execution.
Not so much.
On 452026, appearance lecture, Mr. S.K. Tripathi for the petitioner. Mr. Praveen Das for the opposite party. On 452026, the following order was passed after hearing the learned counsel for the petitioner and the learned counsel for the opposite party. It is submitted by the learned counsel for the petitioner in response to the proposition of law noted in the order dated 452026 that he has challenged the order of directing him payment monthly maintenance on certain grounds that his wife is employed and she is not entitled. In response thereto, the learned counsel for the petitioner is repeatedly requested to refer to the pleadings before the learned court and the evidence laid to substantiate such pleadings. Substantiate such pleadings. Well, to the said, now the Lord Counsel for the petitioner seeks adjournment, submitting that he has not gone through the pleadings. The Lord Counsel for the petitioner further seeks leave to file affidavit, which is not permissible in view of the law laid down by the Honorable Apex Court in Samima Faruqi versus Sahid Khan, wherein the court has dealt with the scope of revision. Also, in view of the judgment scope of revision at paragraph 19 and 20. This court, while exercising its power under Article 227, read with Article 226, cannot allow the pleadings to be enhanced or expanded. Stop. The copy, in view of the adjournment sought for by the petitioner to grant further opportunity, the matter shall be listed the week commencing. They are listed for orders in the week commencing. 27-26. Copy of this order shall be forwarded to the Honorable Judge Family Court Bhubaneswar to be kept in the records of CP number 1198-2022. Yeah. I would add in the decision in Rajneesh versus Neha, the Honorable Apex Court have dealt extensively the law regarding maintenance pendental right to be directed to be paid under Section 24 of the Hindu Marriage Act when petition is pending before the Lord Family Court. Paragraphs there. Quote kare dakani paragraphs number ke likhte. Stop. Yes. Sub item tare.
My lord, that is my application. I have filed for, my lord, enhancement of the same order. My lord.
Sub item likhuntu in view of the order passed in the connected item listed together. The matter shall be listed for orders along with WPC on in the week commencing 27-24. Yes.
Item 30.
Wait, please, Your Lordship.
Yes.
This is that password renewal matter, madam. Ithre, my lord, last occasion, Your Lordship observed that the party may talk to each other, and in that regard, my lord, to clear the apprehension in the mind of the father that the petitioner number 2 child may be taken out of the jurisdiction of this honorable court, the petitioner mother, she is ready to give the undertaking that she will not take the child permanently out of the jurisdiction of this honorable court, and this is only a temporary arrangement.
This court is not taking up the matter. You have to file that before the trial court.
My lord.
Because the original petition is not before this court.
My lord. My lord.
So you go ahead and do that.
My lord.
Do that. Serve a copy.
My lord.
So at least it is satisfying that you have achieved something when both the parties are achieved, because there is a lot of misgivings between them.
My lord.
So they deserve much better. Looking at them, they deserve much better in life.
My lord.
Anyone present for the other statement?
Maybe through virtual mode, my lord.
Yes, yes. This is item 30. 30.
My lord, item 30.
Mr. Barisal, yes, Mr. Barisal was appearing.
Yes, my lord.
अच्छी देखिले BA टाइप कले BAIRISAL चित्तरंजन अच्छी तब क्लिक करो एडमिट करो जॉइन करी ना जॉइन से वेटिंग रे थिले बोले Yes, Mr. Barisal, unmute. Unmute your audio.
Yes, Lord.
I mean, you could not have heard what Mr. Agarwal said. Mr. Khandelwal, I think. You are Mr. R.K. Agarwal?
My lord, my lord.
I think you were not there in the VC when he said, sir. So he refers to the order dated 15/5/2026.
15/5/2006.
The last order. Para 12. Para 10 rather. Para. Yes, para 10. Can you read that? You have it, Mr. Barisal?
No, right now I don't have, my lord.
Okay, that you should tell that. Then Mr. Agarwal can read it. Mr.
My lord,
Agarwal
my lord.
can read it.
My lord, para 10, my lord. On being further asked, learned counsel for the opposite party submits that regarding the issue, probability of child being taken to Canada by petitioner mother is not an issue before any court, as such an issue is yet to be raised by the opposite party father. However, the learned counsel and the respondent express apprehension as indicated above. It is
So
stated.
that apprehension you can read at para 8, I think, 7 or 8. Para 8 ta just kindly read para 8.
My lord. The
Actually,
reason
he's not having the copy, so just help him. The reason for seeking a direction.
My lord, the reason for seeking a direction to the passport authority during pendency of the application for passport is not clear. As stated before this court today, the learned counsel and the respondent in person are very apprehensive regarding issuance of the passport to the child on the ground that issuance of passport would lead to grant of visa to the child, which will further lead to a situation the child being taken out of the India, that is to Canada, by the mother.
Then read further so that.
In considered view of this court, such correlation and extension of sequence starting with the issuance of passport and the child going to Canada cannot be predicated or contemplated in any event. Every person citizen has a right to have his or her Indian passport as per the Passport Act. On being further asked, learned counsel for the opposite party submits that regarding the issue, probability of the child being taken to Canada by petitioner mother is not an issue before any court, as such an issue is yet to be raised by the opposite party father. However, the learned counsel and the respondent express apprehension as indicated above. It is stated by the learned counsel for the respondent as well as the respondent appearing in person that earlier Indian passport was issued without informing the respondent father. To said proposition, the answer would be that if issuance of passport to a child is possible in accordance with law through either of the parents, that is mother or father, passport having been issued without knowledge of the father or mother, as the case may be, cannot be made an issue. The parties having been spoken to at length, it is hoped that they will agree for the welfare of the child with arrangement for shared custody, parentage, stay visitation, etc., regarding which they need to talk to each other as well as to learned counsel appearing for them and the learned senior counsel. The child now being aged about 11 years deserve the best in the circumstances. Your Lordship. Your Lordship is not audible, my lord.
I'm so sorry. Actually,
My
I
lord.
had, I was instructing, so I had.
My lord.
So have you have heard the order? That is the order actually. So, Mr. Agarwal's response is that the petitioner will give undertaking to the terms as would be before the court, having where the matter is pending.
My lord.
Giving undertaking that the child will not be taken out of the territorial jurisdiction of the court.
My lord.
So that is a positive development. I think at least that will
Yes,
assure you and the client. I mean, both the parents are so desperate.
Yes,
Let the child be the uniting factor. And there is otherwise they have everything. There is nothing between them, so that they will be having this kind of difficulty in their exchanges and understanding and interaction.
Well.
So Mr. Agarwal, what you propose? This matter will be kept pending. You will be filing file a copy so that it can be disposed of.
My lord.
Okay. So I am simply adjourning it. I will record, Mr. Agarwal, what you have stated.
My lord.
Or I will simply adjourn.
Your Lordship may observe this that I'll file this undertaking before the
Okay. Yes. I mean that will help in the father also.
My lord.
Yes, my lord.
Because I think is he present today in court?
Yes.
Mother is present, your Lordship.
The father is present.
Father, yes, father is present.
Okay, he's listening. No
Yes,
difficulty. Okay.
Yes, he.
My lord,
Okay,
may I suggest, my lord, one thing, if subject to your Lordship consideration. If your Lordship may remand this matter to Learned Family Court by setting aside that order, and I'll file that this undertaking there, and Learned Family Court, who is in session of the court.
It would be better if it is kept pending because they are so apprehensive. Because I am not passing any order either way.
Your Lordship.
Because I ultimately I leave it to the Learned Trial Court.
Your Lordship.
But I record your submission. Okay.
My lord.
Yes.
Yes, my lord.
Hybrid mode लिखिए. This is item 30. Mr. Mahath, you take your seat. I just because I could find your better half sitting in the court, so I thought that since you are in the chat. Hybrid mode लिखिए. The matter is taken up in VC. The petitioner mother in GUAP 16. And read petition 758 of 2026 is present in court along with Learned Counsel Mr. R.K. Agarwal. The opposite party father is present in chamber of Mr. C. Chittaranjan Barisal, BAIRISAL. The Learned Counsel, Mr. Agarwal, refers to the order dated 15/5/2026, particularly paragraphs paragraph 8, 9. Paragraphs 8 to 11, 8 to 11, 8 to 12, 8 to 12. Stop. It is submitted upon instruction by the Learned Counsel for the petitioner, Mr. Agarwal, petitioner mother, Mr. Agarwal, that to assure the father opposite party, the petitioner shall file undertaking before the Learned Judge, Family Court, so and so, where the GUAP application is pending. The Learned Judge, Family Court, Bhubaneswar, where the CP 666 of 2025 is pending. Giving undertaking that there did not be any apprehension regarding the child being taken to Canada outside sorry, actually clear. There did not be any apprehension regarding the child being taken outside the jurisdiction of the learned court at Bhubaneswar, much less being taken to Canada without following due process and seeking approval that would be necessary, or as the case may be, during pendency of the petition. Stop. It is further submitted by Mr. Agarwal that the petitioner mother also assures that upon issuance of passport to the child, the opposite party father did not be apprehensive of the child being taken to Canada. Stop. But in considered view of this court, the approach of the petitioner mother is very positive, and she shall have the liberty of filing the necessary affidavit oblique undertaking before the learned family court Bhubaneswar in the pending CP number 666 of 2025, as would be directed by the said court. For the said purpose, the matter shall be taken up next date, Janchandi. Or I will direct on a particular date.
No, that is on 17th.
17th?
17th/6. The next date is on 17/6.
Taken up by the learned judge family court, and the said issue shall be considered on the next date of listing, that is 17/6/2025.
No, my lord. It is 20th. It is 20th June. 20th June.
20/6/26.
No, 20/6/26. 20th June.
20/6/26. The learned counsel for the parties shall remain present on the said date before the court and apprise the court regarding the today's order passed by this court. Yes.
My lord, may I request one thing? Request, my lord, since summer vacations are going on, and in this summer vacation, my lord, the child wants to visit to mother in Canada. If your lordship may,
I will not direct that.
My lord.
During pendency of the custody application,
My lord.
I cannot direct transfer of custody in any manner.
Only, my lord, if
because I have already recorded that
my lord,
the child is now, the custody is with the mother.
My lord.
That both of you said.
My lord. At least, my lord, that renewal of passport may not be, my lord, hampered. At least she may be allowed to apply for the renewal of the passport during this time, my lord.
After you give that undertaking before the trial court, you want an early date, you can move. The petitioner shall have the liberty to move the court for fixing, for advancing the date of next date of listing with consent of the opposite party regarding giving of the undertaking.
My lord.
So you work out that.
My lord.
But the problem is that you must understand that she may be genuinely, she will like to take the child to Canada, but that is not an immediate solution or immediate issue.
My lord.
Ultimately, it has to go to the process of the custody being decided by the court. And both of you are pursuing that, so please go ahead, wait for that.
My lord.
ଆପଣ ସବୁ ଜିନିଷ ସାଙ୍ଗେ ସାଙ୍ଗେ କରିବାକୁ ହେଲେ ହବନି, it will not work that way.
My lord.
Yes.
Obvious.
Well, in fact, in any custody matter, one has to be very patient.
My lord, I
And
understand.
more so when, because it is not like peri consagra where the child is 18 and he decides.
My lord, I understand. Obvious.
And more so, Mr. Agarwal and Mr. Barisal, both of you should work out that both the parents should have the company of the child.
Yes, ma'am.
There should not be kind of a feeling of deprivation.
The unfortunate part is
And longing on the mind of the parent that he or she is unable to meet the child. Both of them, both mother and father. Please work out that.
Yes.
Yes. And in fact, you don't find a senior Mr. SP Misra, he can also act as the mediator.
My lord.
Even if she appears for the mother, you need not be apprehensive that he will have a view, particular view. He will look at interest of both the parties.
My lord.
So work it out. Hope for the best.
My lord.
This will come for orders when? Second date केवे 17 कहउछन्ती
after filing of the undertaking.
हाँ नहीं आपनकर केबे डेट एक्चुअली केबे कहले गोटे अछि
20th June, my lord. That is.
अच्छा. The matter shall be listed in the week commencing 6-7 रे आसु.
Yes, my lord.
Yes. Because 29/6 will be too close. Can ଆପଣ जो प्रथम दिन appear करिवे से दिन maybe terms of the undertaking and all that you discuss and finalize.
My lord.
The learned counsel for the parties have worked out a solution acceptable to both the parties. Yes, amicable solution acceptable to both the parties. Yes. Second sub-item hobo. The matter is listed along with GUAP 16 of 2025. In view of the order passed therein, the matter shall be listed in the week commencing 20 6-7-20-26 along with the said application.
My lord, interim order is there in the sub item, my lord.
WPC.
Yes, my lord.
The interim order passed, interim order dated so and so shall continue till the next date of hearing. Third sub item.
Same, my lord.
Interim order is there.
Yes, my lord. Because both the yes, my lord. Yes.
764 is same order as in 758.
One of that order is need not be executed. That was the specific order.
Sorry?
One portion of the order was not to be executed.
First part actually.
My lord, order dated 12th January 2026. My lord, paragraph number 4, my lord. As an entry measure, it is directed that the portion of the aforesaid order dated 2nd January 2026 as reproduced above shall not be given effect to, wherein the learned family court has directed the police authorities for sending the child to pursue his study in Puri, my lord. So that portion was.
Both these writ applications are no more. They have infructuous.
Yes.
Because last day I suggested, but you said that let it be kept pending. Both the writ applications can be disposed of today also.
Yes, my lord.
So you want it disposal today, Mr. Agarwal?
My lord, with that observation that since child is studying in the Bhubaneswar, let him continue, my lord. With that observation, the writ petition may be disposed of, my lord.
Both 758 and 764.
My lord, because both are.
Yes, my lord.
758 lekhuntu. The writ petition has been listed along with the connected GUAP 16 of 2025, wherein orders have been passed after hearing the learned counsel for the parties. 758 lekhiye Mr. R.K. Agrawal for the petitioner, Mr. Chittaranjan Bahri sir for the opposite party. The writ petition was filed regarding admission of the child born from the wedlock between the petitioner and the opposite party. admission of the child into to school. Hello. To a school for his studies. তারপর লিখুন তো, during pendency of the writ petition, the child has taken admission to
KIT International School.
KIT International.
KIT International School at Bhubaneswar. As the saying goes, the same is a reputed school. Both the parents are happy regarding schooling and education of the child. Nothing survives for adjudication in the writ petitions. That the court is single order content in the writ applications. Accordingly, both the applications are disposed of.
My lord,
Sorry?
It may be observed my lord, that he may continue, because what will happen, my lord, once this writ petition is disposed of, that order of the families that remains, my lord, to my understanding, my lord.
Already that has been observed.
In view of the this court observing and taking note of the fact that the child has taken admission in a school at Bhubaneswar, which is in the best interest of the child, as well as the parents are happy with for the child. The earlier order, if any, the earlier orders passed by the Lord Judge Family Court, Bhubaneswar, in so and so, merges with the order passed by this court.
My lord, I am obliged.
Yes.
Item 31.
31, my lord, on behalf of Mr. Opera's boy, my lord. My lord, on
31 कौन कौन sir?
My lord, on behalf of Mr. Opera's boy, my lord, kindly let it come after Bhakasan, my lord. He has gone to his village, my lord.
Village रे net नहीं. You are Mr. Jenna.
No, my lord. My name is Shankar Sahu.
Mr. Shankar Sahu on behalf of Opera's boy for the petitioner. 31. The matter is listed for orders. The matter orders today. Earlier on 17/3/2026, the matter was heard at length. The facts as well as the legal propositions were noted in some detail. ଆପଣ ପାରା 3 ଆଉ 4 ରେ କଣ ଆନ୍ସର କଣ ଭିଲେଜ ଦେଖୁନାହାନ୍ତି ଭିସି ରେ ଆପିୟର କଲେ ତ ଆପଣଙ୍କର ଅର୍ଡରଟା ଅଛି ନା in response to the paragraph 3 and 4 of the order dated 17/3/2026, the Learned Proxy Council has no answer. And he seeks accommodation in absence of the Learned Arguing Council on personal grounds. Stop. To grant further opportunity to the petitioner, the matter shall be listed for orders in the week commencing 6/7/2026. Yes.
32.
Sushant Legut. SUSANTA. के बारीक देखिए A. बारीक कहर KNHAR नहीं नहाते के नहाते और वेटिंग रूम रे नहाते ठीक अच्छे petitioner none. The matter was heard at some length on 8/5/2026. The facts, the relevant facts as well as the propositions of law were noted. Stop. The allotted counsel for the petitioner and adjournment to address. Today, when the none appears from the petitioner, when the matter is called, to grant further opportunity, the matter shall be listed for orders in the week commencing 20/7/2026.
33.
Well, in this appeal, project proponent, I have filed a IA for addition of project proponent as a necessary party. So tomorrow, it is being drafted. Project proponent, I will make the.
ସେ କହୁଛନ୍ତି ଆପଣ କଣ ଆଜି ଫାଇଲ କଲେ ନା ତ 4ଟା ବାଜିଗଲା
କାଲି ଟୁମୋରୋ
ତାହେଲେ କାଲିକୁ ସେମିତି ପୋଷ୍ଟିଂ କରିଦିଅ କାଲି ପୋଷ୍ଟିଂ କରିଦିଅ ହେଲା ଏଟା କେତେ ନମ୍ବର ଆଇଟମ
ଏଟା 33
କାଲି ସେମିତି ନେଇ ଆସେ କାଲି ନା ଆଫ୍ଟର ଭେକେସନ ମିଷ୍ଟର ମହାନ୍ତି
ମାଇଲଟ ଏଟା ଆସୁ ଡେ ଆଫ୍ଟର ବିକଜ ନମ୍ବର ହବ ଡେ ଆଫ୍ଟର ଟୁମୋରୋ
ଶୁଣନ୍ତୁ ଆପଣଙ୍କର ଆଜି ଯେମିତି ଡିଫିକଲ୍ଟି ଦେଖିଥିବେ many of the council they were ready with some documents which I cannot receive. So kali to apna pokkhala khaibe na khaunanti. So kali jodi kali to court hobo pahar dina fer BC ei jo kali hele apanଙ୍କର ei jo joda ko aji apna document file korchenti
kali by 10:30-11 I will get the number.
Are number copy ta fer debe na number is not important court pai ठीक अछि kali रखो kali asu
आगे
हाँ ठीक है yes 33 Mr. Behra tomorrow Prabhu
yes my lord
yes 34 सौम्य लिखंतु टाइप करंतु SOUMYA JYOTI लिस्ट कोटे ଦେଇଛନ୍ତି କୋଟେ ଲିଷ୍ଟ ଦିଅନ୍ତୁ ସୌମ୍ୟ ନାହାନ୍ତି R.Ray
Your Lordship, I am appearing for the opposite party in this item number 34.
Right, sir. You are Mr. Tirth Kumar.
Lokesh Gaurav Maharana, LG Maharana.
LG Lokesh Gaurav. So I think no one is there in the VC for the petitioner because we have searched his name but not appearing. Petitioner none, Mr. Lokesh Gaurav Maharana, L.G. Maharana for the opposite party. So Maharana, can you hear some music playing in the background?
No, Your Lordship. I can.
Thank you. Because the problem is that there is some mela going on, so they are playing music. So you must be thinking that what has happened. So Mr. Prabhu also cannot hear this.
No, my lord.
Okay, that's good. At least even if I am disturbed, you are not disturbed.
There is something called voice cancellation that would have been applied to your lordship's system.
Oh, so voice cancellation code. Sir, here. You are right. They have applied.
Because of the technology, my lords, we are.
So they are playing the old Odia songs to attract all of you to join the Mela. So now this place has become 24/7 Mela actually. Some Mela is going on. None appears for the petitioner when the matter is called. The learned counsel for the opposite party is present. To grant further opportunity to the petitioner, the matter shall be listed for orders in the week commencing 20/7/2026. Yes, Mr. Maharana.
Yes, Your Lordship.
The entry order to continue.
If it is vacated, then it would be good for the petitioner, for the respondent.
respondent. But the problem is that but a condition early कर दियो तो ठीक. The matter shall be listed in the week commencing on 29. The interim order dated in absence of the petitioner. एमती लिखंतु 29 हैला तापरे पारा करिवे. However, comma, in the absence of the petitioner, the order dated 10/4/2026 is reiterated. Interim order dated 10/4/2026 is reiterated. It's directed that the CP number 73 of 2025 pending before the Learned Judge Family Court Rayagada shall be adjourned to a date beyond 6/7/2026 as would be convenient to the Learned Court in season of the matter upon a prayer being made for the said purpose. Thank you, Mr. Marana. Because you have to be fair in the situation also. That is expected. You are officer of the court.
Absolutely.
Yes.
Grateful.
Yes.
36, my lord. We have received a counter last week, my lord. 1 week time we granted for filing of rejoinder, my lord.
Mr. Senior Ratho will be appearing.
My lord.
Mr. J.K. Ratho, Senior Advocate, along with Mr. A.K. Shah for the petitioner. It is submitted by the Lord Instructing Counsel for the petitioner that copy of the counter has been served on them and they will obtain instruction on their note. The copy of the counter filed by the opposite party state has been served. Stop. It is submitted. The petitioner may be granted time to file rejoinder in response to the counter. Accordingly, the matter shall be listed for admission in the week commencing 27/7/2026. Rejoinder, if any, shall be filed within 6/7/2026. Mr. Sir, 6/7
My lord.
Upon serving copy thereof on the Lord Counsel for the state. I think since the rest of the matters are hearing matters, it would be better if they are taken up after vacation.
My lord, item 37 should by mistake come in or admission, but I filed an application for vacation of the stay.
So one second.
But
So
it
now,
by come on, madam.
so let us do one thing. We will go serial. Okay.
Item 30.
Lordship, can I just make a mention?
Item
Item 34.
No.
Item 37, my lord.
Mrs. Senapati, just
Yes,
wait.
sir.
I'm there. I'm not leaving. I'm telling you something. So we are going page wise since there is some difficulty actually today. Also, you would have marked that. So
my lord,
we'll go page wise. So item 37.
Again.
Item 37. Yes, my lord. Item 37, Mr. D.R. Ratho was supposed to appear before your lordship. Since he has some personal difficulties, he is unable to appear before your lordship. So he requested me to appear before your lordship. So there is
today filed by... No, Mr. Kora, we are not taking up the matter for hearing because these are all hearing matters.
Lordship may fix any other date since my learned senior appearing for opposite party has filed an application that as it appears in the...
Yes, that is mentioning. Mr. Acharya is mentioning.
Your lordship may kindly allow me some time to file the objection to that IA. Your lordship may fix any other date for hearing of that matter. That is all.
My submission that mistake that I may be listed for orders, my lord.
Yes, 1 second. I am telling.
My lord.
So he wants it to be ordered because the IA has been filed. So let it be there for orders.
Again.
Yes.
Mr.
My lord, the IA has been filing 2024 since 2002 years, my lord. They are not filing an objection.
Mr. Subhendu Kara, on behalf of A.R. Das for the petitioner, on behalf of D.R. Ratho.
I am along with them. I have power in that matter. So your lordship may...
Yes,
madam.
Mr. Subhendu Kara, on behalf of along with Mr. D.R. Ratho for the petitioner, or Subhendu Kara for the petitioner, Mr. P.C. Acharya for the opposite party. The learned counsel for the opposite party submits that he has filed IA. Copy of IA has been served. the learned counsel, Mr. Kora, submits that the learned arguing counsel, Mr. Ratha, has some personal difficulty and he could not appear. Stop. Accordingly, the matter shall be listed for orders in the week commencing
27
27 26
मतलब 26 माइल 26 माइल
6
ଓଡ଼ିଶା ଯୋଉ ଆଜ୍ଞା ଛୁଟି ଥିବ ନା 22nd
से 22 6 माइल 22 6 because the petition is suffering my lord
ଆଜ୍ଞା ହଁ ଯେ ସବୁ ଯାକ ମ୍ୟାଟର ଆପଣ ରିଓପନିଂ ରେ ରଖିଲେ
ଏ ସାତଟା ଅଳ୍ପ ଆଜ୍ଞା ଖାଲି ଚାଇଲ୍ଡ ପାଉନି ପଇସାଟା ପାଠ ଆଡମିସନ କରିପାରୁନି 7,000 ଟଙ୍କା ଦଉଛନ୍ତି
ସାର୍ ଜୁନ ରେ ରହିଲା ସାର୍
ତେଣୁ ଆକାଡେମିକ ସେସନ ୱିଲ୍ ଗो ମାଇ ଲର୍ଡ
what I
only
pray is your
only difficulties my lord
ଆଡମିସନ ସରିଗଲାଣି ସାର୍ 29/6 we commencing 29/6/2026 for taking up of the IA for consideration of the IA
for orders
before that I will file my objection to that IM.
Yes.
you also mentioned that
the petitioner shall have liberty to file the objection to the IA upon serving copy thereof by 23/6/2024.
Grateful. Deeply grateful, Lordship. Interim order, if any, my lord.
Interim order thila kete likhi debe interim order thile continue kar debe
till that
yes
Grateful, your Lordship. Deeply
yes,
obliged.
39
39 ro 34 se kon mention korchanti Mr. Senapati what you are saying
Yes, your lordship, item number 34. I was present in the VC, but I was not being.
See, that is some issue. If you are allowing everyone, there is a problem. You have now even it has again surfaced. So I mean, don't take it otherwise. So your presence will be marked.
Yes, your lordship.
Yes, Senapati for petitioner 34 add kar debe. Lokesh Maharana, the interim order has been mentioned. Mr. Maharana was fair enough to say mention that.
Much obliged, your lordship.
Yes. Pardon, your lordship. Absence of it kati do. Simply adjourn karibe. Interim order karibe.
Item 38. Item 38. Item 32, your lordship.
38
Item 32 I could not be connected, your lordship.
No, ଆପଣଙ୍କୁ ଆମେ ଖୋଜିଥିଲୁ ଆମେ ସର୍ଚ୍ଚ ୱାରେଣ୍ଟ ବି ପଠେଇଥିଲୁ ଦେଖିଛନ୍ତି ଅଦର୍ସ we typed your name ସୁଶାନ୍ତ ପୁରା ଟାଇପ କରାଗଲା ଆସିଲାନି
ମୁଁ ଆଉ ଥିଲି ଆଉ ଗୋଟେ କୋର୍ଟ କୁ ପଳେଇଲି ତାପରେ ଆସିଲା ବେଳକୁ ଆଉ ଇଏ
ଆଉ ହେଲାନି ଆପଣ ଅନ୍ୟ କୋର୍ଟ କୁ ଭଲ ପାଉଛନ୍ତି ଭଲ କଥା ଆମେ ବି କିଛି ଖରାପ ନୁହଁ ଆମେ ବି କିଛି ଆଡଭର୍ସ ଅର୍ଡର ହେଇଯାଏ
ଏ ସିଷ୍ଟମ ତ
କେବେ 32 ରେ କେବେ ଗଲା 27 32 ଟନା ପେରିସା ସୁଶାନ୍ତ କୁମାର ବରାଳ we commencing 27 Mr. Bharat.
Item 39. 38, my lord, sir.
38 Mr.
Well, I am for the petitioner, my lord.
Yes. Say actually Mr. Nayak, Mr. Sodangi adjourn kale.
Aye.
27.
Aye. Written note submission file है जी.
But obviously it will not be apt to start hearing in VC also.
Aye.
39.
My lord, 39. In this case, my lord,
I am for the petitioner.
The husband.
I pray that this matter kindly be taken up after vacation. I will obtain instruction about this.
I am sorry to say, my lords, because the husband is getting 5 lakhs towards salary. 15,000 is under challenge by the husband.
Mr. Pradhan will
7,000.
Mr. Pradhan, you persuade him.
There is an interim order passed by this honorable court. I am complying that order.
That only paying 4,000 rupees to mother and daughter.
This honorable court are directed to pay 4,000.
And meanwhile, all the evidence has been closed and the case has been posted for argument.
And that's why I want to obtain instruction from my client.
Kushti, it will not be possible. Now there is already no time. Time is almost over. And it will not be ideal to start hearing in VC. There is some issue. So there will be. So 39, you agree for a date, Mr. Kushti?
39, my lords. May I pray, my lords? I'm a liberty be given to me that I shall file one time application and that this honorable court is in session of the matter and the trial court will pass adjourn the matter because just on the reopening date, the date has been fixed.
for argument in the matter.
There is no difficulties in proceed with the divorce proceeding. But here I have challenged the
Say,
interim
Mr. Pradhan, you accommodate. To that extent, it can be deferred. Since it is not state, it can be taken up on another date. See what a date ଚାହୁଁଛନ୍ତି.
Divorce proceeding that date differ କରି କଣ ଲାଭ କଣ?
ସେ କରନ୍ତୁ ସେ କଣ ପାଇଁ
24 interim application under section
ଓକିଲ
24.
ଆଜ୍ଞା କାହିଁକି adjournment ନିଅନ୍ତି it's a mystery. ସେଥିପାଇଁ କୋର୍ଟ କୁ ବ୍ଲେମ କରାଯାଏ କିନ୍ତୁ କାହିଁକି ନିଅନ୍ତି adjournment ସେଟା ତ ଆପଣ ଯଦି ପଚାରିଲେ ବଡ difficult question ପଚାରୁଛନ୍ତି.
ନା ଏଠି ତ ମୋ interim application interim order ଟା ମୁଁ challenge କରିଛି interim maintenance award ଟା.
Correct, he knows that. That is how he is saying that ମତେ reopening ରେ ଗୋଟେ ଆପଣ କେବେ କୁ adjourn ଦେଲେ ହବ Mr. Prusti?
My lord.
କେବେ କୁ adjournment ଚାହୁଁଛନ୍ତି? You have heard Mr. Pradhan. He says that where is there is no need to adjourn the divorce proceeding.
After vacation on that day, I shall pray for any adjournment. Not to
କେବେ କୁ ଚାହୁଁଛନ୍ତି?
after vacation any date.
Any date तो calendar refer କରିବାକୁ ପଡିବ any date. Lower court ଟା ପଡିବ.
Bye.
ସେଠି ଅଛି.
It is not a case of the opposite party. I am disobeying the order passed by this court. This court directed to pay certain amount. I am paying that amount.
He is not saying that. He never said. He is very clear. He says that is how he is saying that only this much of amount being paid to the mother and child. He would have simply said that order is not complied with.
I guess the divorce proceeding has sorry. The divorce proceeding has sorry. Both party will be jaha will the dispute close ହେଇଯିବ ନା କାହିଁକି ସେମାନେ linger କରିବା ପାଇଁ ଚାହୁଁଛନ୍ତି there is no I don't understand why
My lord.
ସେଥିରେ ଡେଟ୍ କରିଦିଅନ୍ତୁ 39 ସେଟା ହେଇପାରିବ
ତାଙ୍କ difficulty personal difficulty ଅଛି then only ମୁଁ କହିଦେବି yes ଆଜ୍ଞା adjourn କରିଦିଅନ୍ତୁ ଯଦି personal difficulties ନାହିଁ ତାହେଲେ
ସେଠି କରିବେ 29 ରେ ଆସୁ 39 ହେଲା 40 Mr. Bhuya, Mr. Satpathy, Mr. Das.
Item 40, my lord, lengthy hearing is required for this matter, my lord. It might be posted any day after vacation.
ସେ କଣ କହୁଛନ୍ତି କଣ dispose of ହେଇଗଲା ଦରକାର ନାହିଁ ପେଣ୍ଡିଂ ରହିବ ଏଇଟା ମେନସନ କରୁଥିଲେ ମିଷ୍ଟର
ନା my lord, CP type of the pending ଅଛି the divorce
ଅଛି ଠିକ ଅଛି ତାହେଲେ 40 ଟା ଡେଟ୍ କରନ୍ତୁ where is Mr. Das ଠିକ ସମୟରେ ପଳେଇଲେ ତ ତାଙ୍କ ନାଁ ଲେଖନ୍ତୁ ମନ୍ମୟ MANMAY ହାଇ ଡେ ପାର୍ଟିସିପେଣ୍ଟ ଟାଇପ କରନ୍ତୁ MAN ନାଇଁ ନାହାନ୍ତି ଗୋଟେ ଅଲରେଡି ଡେଟ୍ କରିଦିଅନ୍ତୁ 40 ଟା
କାଲି ଗୀତା ମେନସନ କରନ୍ତୁ
ଆଚ୍ଛା ଏଟା କାଲି ଆପଣ କାଲି ତାହେଲେ ଏଟା କାଲିକୁ ରହିଛି କାଲିକୁ ଆପଣ କହିବେ ସର ବୁୟା
ଆଜ୍ଞା
ସେଥିରେ ସେ ଆପଣ ଫର ଆଡମିସନ କାଲିକି ଅଛି ତ
ନାଇଁ ଫରୱାର୍ଡ
ଠିକ ଅଛି କାଲି ଫର ଆଡମିସନ କରନ୍ତୁ ହେଲା
much obliged, man.
ତାପରେ
47
46 କହୁଛନ୍ତି 46 Mr. Chatterjee 46 କଣ
Yes, Lord. I am praying for an adjournment after vacation.
46 କଣ ଡେଟ୍ ଦରକାର ଆପଣଙ୍କର
Any specific date?
46 ଯାହାଲେ ଡେଟ୍ କରିଦେ
कोई काम से 36
7 କଲେ କି ବଡ ପାଟରେ କୁହନ୍ତୁ
Pardon, my lord.
Item 47, my lord.
Item number 48 I mentioned before.
47 କହୁଛନ୍ତି 47
Yeah, 47, my lord. Last your lordship may see that order dated 10/4/2026.
Yes.
Put of the matter in the week commencing from
Mr. Swine is present. Mr. Swine, Mr. Sahoo, what do date कर दियो
my lord. No stay has
any short earlier adjournment may be taken, your lordship. 22, 23, 24, 25 any date your lordship may
29 week कर दियो तो
वो काम से
my lord, as the interim, my lord, there was liberty was given to the petitioner to seek the adjournment before the lower court.
अच्छा सेटा कर देबे हेले
yes
आपनकर एटा केते आइटम कहउछनी 47 रे
my lord.
Mr. R.K. Sahoo for the petitioner, Mr. R.K. Swai for the opposite party. The matter could not reach the intellectual paucity of time in intervenes. The matter could not reach during course of the day's proceeding. Stop. The learned counsel for the petitioner seeks extension of the interim order dated 8. The matter shall be listed for order for admission in the week commencing 29/6/2026 से जो सीपी नंबर एते सैंपल अर्जेंट बियॉन्ड 6/7 से सेंटेंस आप कंप्लीट कर दो है तो डेट टा चेंज कर कंप्लीट द सेंटेंस यस
Pardon, my lord. Item number.
So, Panda, item 48, Mr. Panda.
My lord. Here, your lordship, the TRB petition was filed by the petitioner continuously not attending
No,
the
sir,
court.
take a date, sir. Time is over.
Tomorrow.
केबे चाहुचंती सर
My lord.
केबे चाहुचंती
Any day, my lord, but I think tomorrow or my lord's
मोर
convenience.
आपण पखळा खाइबे को आपण इनविटेशन अछि I have been told you take a huge quantity of पखळा along with fish fry.
देखो my lord's convenience गुटे for short date तो पड़
Short date तो टोटल 2 दिन अछि गोटे दिन पखळा 3 दिन अछि तापर आउट दिन रेफरेट unfortunately members have passed away.
और रीओपनिंग कर दियो तो हजूर
48 करंतु रे
कोई काम से
29/6 सर
29/6
आगे इमीडिएटली आसुची से पढियोनी 29/6 रे 120 टा मैटर अछि से ऐड कर चलचन कर दे
माने ऑर्डर से आसिले गोटे 10 मिनिट सर जीव
सर ऑर्डर से आनी होबनी सर then it becomes impossible actually now even orders matter are being hard
कोन हिच माने खाली सिंपली टीआरबी पिटिशन फाइल इची ओनली टू ट्रांसफर
let us see liberty to mention is there let us hope for the best हला तापर 49 to 50 anyone mentioning then 51 to 54
my lord pardon my lord 43 item I am for the
43
petition
date चाहुचंती
first week of the July
43 कर दियो
53
Lordship
51 any date of July first week of July Lordship 51
like 48 केबे कले 43 sorry 43 हां
ओके एकदम 6/7
week
my lord
52 I don't know 53 my lord 52 item my lord
53 Mr.
previous arrangement that once application for adjournment is filed in the trial court will adjourn the case that arrangement may continue
53 रे करते Mr. Subhasis Patnaik Mr. Parija is there
I am for the petitioner he is for the opposition
I understand Aryan Parija LP Behra for the opposite party type करो 53 से order कर दो paucity of time intervenes the matter could not reach during the day's proceeding the learned counsel for the petitioner mentions the matter and submits that interim order dated so and so may be extended. Accordingly, it is directed. On date केवे कले 53?
We commencing 20/7.
We commencing 20/7. The matters have been listed. We commencing 20/7. अपने prayer being made चढ़ा कर देवे 27/7. Shall be listed adjourned beyond 27/7.
problem. 51 your lordship
54 my lord
52 my lord
नहीं अपन DSA कोटा कोचंती कहले एटा
Your Lordship, I am, Your Lordship, Mr. Saurav Tibrewal, Your Lordship, item 51, Your Lordship. Wrongly, my name is reflecting 51, Your Lordship. 51, I'm there, Your Lordship, for the respondent.
51 you want a date?
Yes, Your Lordship. First week of July, Your Lordship.
51 what a date करो?
We commencing 27/7.
Your Lordship, any shorter date, Your Lordship?
Shorter date रे से तब करिका house he has crossed already 120 in some days some weeks actually
Lordship
because the method now is that to let us to the realistic estimate of whether the matter will reach
my lord item 52
51 27 week कर दो 52
my lord 52 is very small question has to be decided in which stage the electronic record will be marked MO. So any date after vacation, a date be fixed.
We commencing 13/7.
we commencing 13/7 कर दियो ता करो item 51 52 टा 27 कर दियो
last but not least 54
Yes.
item then
yes sir
54
Sir, how can you be the last? You are neither last, but also not least. Superda. You are always fast and the best.
Yes.
6 lakhs रो आउटस्टैंडिंग अछि पूरा एरिया आ तापरे 3rd February हेलानी आसीनी एडी 23rd रे हो
29/6 आसु 54
My lord, and connected matter also RPFM 85/26 wherein the
85
opposite party hearing is the petitioner there.
54 रे
ଆଜ୍ଞା 54
PFM 38 ସାଙ୍ଗରେ
ଆଜ୍ଞା ଆଜ୍ଞା
ଆପଣଙ୍କର କିଏ ଅଛନ୍ତି
ମେମୋଟା ଦେବି ସେ
କିଏ ଅଛନ୍ତି ସେ ରିସିଭ୍ କିଏ করে ଆପଣ ତ ଏଠି ଅଛନ୍ତି
ଏଠି ତ ସେ ବର୍ଷା ମ୍ୟାଡାମ ଅଛନ୍ତି
ବର୍ଷା ମ୍ୟାଡାମ ରଖିବେ ମେମୋ ଆପଣ ଦେଇ ଦିଅନ୍ତୁ ଓମ୍ ସ୍ୱରୂପ
ଆଜ୍ଞା ଆଜ୍ଞା ମୁଁ ଦେଇ ଦଉଛି 85/26 ଖାଲି ଅର୍ଡର ରହିଲେ
ସେ ତ ଏଇଟା 9 ନମ୍ବର କୋର୍ଟ ତ ଚାଲିଛି ତ
ଆଜ୍ଞା ସେଠି ମ୍ୟାଡାମ ଜଣେ ଅଛନ୍ତି କମ୍ପ୍ୟୁଟର
ହଁ କମ୍ପ୍ୟୁଟରରେ ବର୍ଷା ମ୍ୟାଡାମ ଥିବେ ତାଙ୍କୁ ଦେଇଦେବେ ଆପଣ ଯୋଉଟା RPFM 38 ଅଛି ମିଷ୍ଟର ପରିଡ଼ା ମେନସନ କଲେ ତା ସାଙ୍ଗରେ ଆସିବ ତ
ହଁ RPFM 85/26
ଦୁଇଟି ଯାକ ଲେଖିକି ଦେଇ ଦିଅନ୍ତୁ
ଠିକ ଅଛି ଠିକ ଅଛି
ସେଟା କରିବେ ପ୍ରୋସିଡିଂ କଲା ବେଳେ କୋର୍ଟ ମାଷ୍ଟର କହୁଛନ୍ତି କରିଦେବେ ସେ ତ ଏଠି ଅଛନ୍ତି ବର୍ତ୍ତମାନ ସେ ସେଠିକି ଯିବେ ପ୍ରୋସିଡିଂ କରିବେ ହଁ
29
ଆପଣଙ୍କ ଆଇଟମ ନମ୍ବର କେସ୍ ନମ୍ବର ଲେଖିକି ଥୋଇ ଦିଅନ୍ତୁ କିଛି ନଥିଲେ ବି ସେ କୋର୍ଟ ମାଷ୍ଟରଙ୍କ ଟେବୁଲ ଉପରେ ଥୋଇଦେଲେ ସେ ବୁଝିଯିବେ
ଠିକ ଅଛି ଆଜ୍ଞା
ସେ କ'ଣ ଆପଣଙ୍କ କାମ ସବୁ କରିଦେବେ ବୋଲି କହୁଛନ୍ତି ସୋ ଥ୍ୟାଙ୍କ୍ସ ଟୁ ଅଲ୍ ଅଫ୍ ୟୁ
ଆଜ୍ଞା 29 ରହିଲା ତ ଅବଲାଇଜଡ
29 କରିଛନ୍ତି ତ
ମ୍ୟାଡ଼ାମ ଲେଖିଦେବି ଗୋଟେ